For item number 17 is concerned, that is item number 17, that delivery metal yesterday's metal slot, that may be tagged with 3715 of 2020, which is
Which
with the
matter is connected with that?
which is with
Arthur, the learned counsel appearing on behalf of the petitioner submits that the instant writ petition is connected with the batch of writ petition. Wherein the court had fixed the matter on 13th.
on 6th of August.
No, 13th. On 13th of August 2024. So accordingly, the instant writ petition be listed on 13th of August 2024.
May I please allow, sir?
Along with WPC number
3715 of 2020.
May I please allow, sir? The concern of the other side, I beg to mention item number 29 to 33, your lordship. 29 to 33. In this matter, department is going for amicus, trying to amicus settlement with the petitioner, your lordship. Out of court settlement, department, non-payment of contractual dues, your lordship. So we have taken the consent, the process is going on in some time for the outcome of the settlement, your lordship. We have taken consent of the other side, your lordship,
for what?
for this amicable settlement, your lordship, between.
R.R. Gogoi, the learned counsel appearing on behalf of the PHC. Is that the matter?
Yes, the MSME matters, your lordship.
Then you have not paid.
We are not paid, we are going for amicable settlement, lordship. We have asked for them to come and do for amicable settlement. The process is going on, lordship.
Huh?
The process is going on, amicable settlement.
There was a direction to make the payment and there was he said that he is going to
Some
pay the
principal amounts,
21 lakhs or 22 lakhs.
principal amount has been paid, lordship. But
Then
the interest amount is yet to be paid. So they were trying to do an amicable settlement with the petitioner, lordship.
it has been submitted by the learned counsel appearing on behalf of the PHE that the principal amount as directed by this court have already been paid. However, as regards the interest amount, the same an out-of-court settlement is presently in the process and as such seeks for an accommodation. List the matter again on 9th of September.
Obliged, lord.
Please, lordship.
Take it a day, 29 to 32. 33.
I have planned item 36 minute. Item 36 minute, I have some difficulties today. Will not kindly adjourn this case for today only. Any day that proceeding can be taken.
Why?
Difficulties.
What difficulty?
To go somewhere else.
So we'll take up the matter as item number 1.
One, not item number 36.
Understood. 36 will convert it into 1. Better over then. You have any difficulty? You are here. What is there to take adjournments in this type of matter? Are you enjoying an interim order? What is the case about?
Regarding the eviction drive which was carried out by the PC Hojai for construction and widening of the road under Assambala scheme, direct purchase was taken up.
Huh?
Assambala scheme, there was a scheme, Assambala scheme. For broadening of the road, the eviction drive was carried out. My name was reflected in the list, mentioning the wrong tag number and pata number. Unreasonably, we have been paid lower amount in comparison to others.
Have they taken the land? Have they taken the land?
The land, but they have not compensated us properly. In fact, they have reflected our tag number and pata number wrongly in the list, and no compensation has been paid as regards our demolition of building, whereas the buildings of other particular persons, they have been paid fair price.
Then, don't you think that this court would be the fit court for passing appropriate land? Then,
I would get to know.
why you are asking for an adjournment?
Some difficulty, that is why.
Fellow, the counsel appearing on behalf of the petitioner seeks for an Huh?
I am the petitioner. Yes, ma'am.
counsel appearing on behalf of the petitioner seeks for an accommodation to establish the matter for 4 weeks.
You may please, the lordship. Lordship, with the consent of the other side, may I mention item 44? Lordship, I appear for the respondents. The impugned notice of demand from the Provident Fund Commissioner. I have instructions that we're withdrawing it. There's a reconciliation of the amounts happening. So the writ petition will become instructions. Moment I get a written instructions, I'll share with the petitioners and they can take instructions to withdraw the petition.
Next week.
We've got oral instructions that the impugn notice will be withdrawn. I'm just awaiting written intimation of that.
Ms. G. Goswami, the Learned Council appearing on behalf of the Assam Tea Employees Provident Fund Organization submits that the impugn notices which have been assailed in the instant petition is likely to be withdrawn as she has received verbal communication in that regard. She, however, submits that the written orders will be passed in a very short time and accordingly seeks for an accommodation. List the matter on 23rd of September 2024. Interim orders passed earlier shall continue.
Lordship, we want actually a short, because we'll issue a fresh notice. Which
No
will,
issue. Let it be there. We'll have it on
no, there
then.
is an interim order that we cannot.
Yeah,
Lordship,
don't
September-
issue.
No, it's Provident Fund, your Lordship. So,
23rd of October.
Lordship,
Don't issue. You should have brought that if you are so clear.
no, Lordship,
Get
there's-
it by 2 o'clock. Or 23rd of September.
okay, we'll get the written intimation at 2 o'clock. So Lordship,
Fantastic. 2
no,
o'clock.
Lordship, please understand. This is dues to Provident Fund.
I understand, madam.
Lordship, if you adjourn
I
it by
know,
2 hours,
I
2
know, but
months,
that
the
is your
prejudice
lookout.
to workers.
The writ petition was filed. Why haven't you got it done, things done?
Lordship, we understand. After it happened and before June, it was
Get
sent
it by
to the
2
authorized-
o'clock or by 4 o'clock. The written instructions, we close it. Then give you the liberty to initiate.
11 o'clock. Lordship, 2 o'clock, it's fine. Lordship, we have to share it with them because they'll have to take instruction. That's why I was asking for accommodation. to
Whether
fight
they
it.
take instruction or not, the moment you bring it before me, I'll close it. No, in there, it has become
All right,
instructions.
2 o'clock then, your
Okay.
Lordship. Obliged.
May I please, your Lordship? I'm praying for listing on motion method tomorrow, Lordship.
May please, your Lordship. Your Lordship, pending matter, I have declination for listing on Monday, your Lordship.
What?
This is a writ petition pertaining to the removal of the panchayat member from our post, your Lordship. This is a covered case, your Lordship. Otherwise, the similar case has already been decided like this one of the court, your Lordship. So we are covered and the affidavit has already been filed by the respondent authority, your Lordship.
Admission?
Right.
When?
Monday or
Wednesday? Wednesday.
high level.
Case item number 50-57.
Lordship, I appear in 55, 56, and 57 for the petitions.
Yes. So your case is that before issuance of the notification under 56, there was no recommendation taken from the
GST council.
My lords.
GST Council. And as such, the issuance of the said notification is wrong. That's your submission.
Not my lord, force measure, there was no force measure, my lord. But since this ground will suffice, since there is no recommendation, my lord, perhaps this ground will suffice. Section 168A clearly says, my lord, there has to be recommendation.
Have they filed any affidavit in any of the matters?
They have filed affidavit, my lord. WPC number 120, 122 and 24, my lord.
Our understanding, my lords, they have filed a common affidavit for all the matters.
My lord, in paragraph 3.8.1, my lord. Internal page 5.
What do they say about the force measure?
Because of pandemic, well, there was less staff, my lord, for working, my lord. Restrictions were there at the time, therefore they could not complete the necessary, my lord, actions, my lord.
Now, in your case, you have not submitted your return.
Annual return I have not submitted.
In your case, did you submit, Mr. Jain?
My lordship, it is submitted.
If you have submitted the return, then
No, if I had submitted, but still within 3 years, they are supposed to pass the order. So that 3 years have elapsed. It is only by virtue of this notification that the time limit has been extended. So if I have filed the return, or in any case, even if I have not filed the return, it is the last date on which I was supposed to file. 3 years are to be computed from that date. And that time period has already elapsed when this notice was issued. And if not for this notification, it is time barred.
now, if you have filed your return,
Lordships.
what notices have been issued to you?
It's the 73 under show cause notice that was issued to me. Under 73, a notice has been issued to me
And for what?
for denying the ITC that I have taken it belatedly.
What?
Under 16.4 that I have taken the credit after the
For
due date.
you have been taken care of by 16.5.
That will, this amendment, budget amendment will take care of that.
So in your case,
Yes.
you have been duly taken care of.
In one of the matters, there are multiple issues. They have denied under 16.4 as well as under 16.2b. 16.2b is that my supplier has not paid the tax to the government. So in one matter, it will not suffice.
Which matter?
In the MISO 55, serial number 55. There are both the issues, 16.2 and 16.
On GST account. Very good. Here. No. Why are you bringing 16.2b?
16.2b because they have denied ITC to on that ground also. 16.2b says that it should be reported in the 2A that my supplier should also pay the tax and he should report in his 3B in his 1 so that it will get reflected in my 2A. So since it was not getting reflected in my 2A, they have denied ITC on that ground also.
Now, what does 16.5 say?
If my not can see the order, it's there.
It starts from which section of the Finance Act?
Which part, my lords? That
Which section?
from 16, section 16 only. That your supplier should have paid the tax to the government. 16 to 10 BA, then C. The subject to the provisions of section 7, the tax charge in respect of such supply has been actually paid to the government, either in cash or through utilization of ITC admissible in respect of the said supply.
In subsection 2, in respect to an invoice note for the supply of goods or supply of both pertaining to the financial, the registered person shall be entitled to take input credit in any return. The amount which is of November. The registration of a person is cancelled under section 20. Now you have filed your assessment by making a claim on that input tax credit.
Lordships, in the return.
Negative by issuance of that notice and then the order.
Yes,
Order has been passed
yes, order has been passed.
under 73.
73.
10.
Yes.
Now, what do you say about the judgment of the Supreme Court in the case of Mohit Minerals?
So Mohit Minerals, my lordship, is that the recommendation from GST, if the parliament has to make a law, then the extent of the revenue in that case was that once the GST council has make a recommendation, that is in itself a law. The Mohit Minerals in that case said that no, the GST council is not equivalent to parliament. Ultimately, act has to be passed by the parliament only. Just merely because the GST council has made a recommendation, that in itself will not translate into a legislation. But in that judgment itself, it is clarified that wherever the government wanted or the legislature wanted that there has to be a recommendation from GST council, in the section itself, they have made this clear. So just like section 168A, a notification has to be issued, it has to be issued on the basis of recommendation from council. So in all the cases,
Let us take the case of
yes,
the 49th meeting, GST meeting,
yes,
where the state center sought for that the
Yes.
period be extended till 2023 or 24,
Yes.
what do you mean?
yes.
That was rejected.
In the 49, yes,
It was rejected and made it only till December 2023.
yes, yes,
If it is made till December 2023, but they sought for under 2000 till 2024
yes,
to March and August 2024,
yes. my lord.
would that take away the powers under 246A?
No, my lords, because 246A, it just gives them the power to legislate. And here, we are not challenging. If they can amend the act, they can very well do. But here, by way of a notification that they are extending, it's a delegated legislation. And the power
But
delegate,
notification is a secondary legislation taking into account that this notification is laid before the Parliament under 166.
my lordship, there is a Supreme Court judgment on this issue that just because it is laid before the parliament, that does not mean that that they can circumvent this process. There's a direct judgment of the Honorable Supreme Court that I can share with my lords.
Which one?
There are if my lords can just I will- I will share it with my colleague.
Don't you think there is a difference between where you have never sought for a recommendation and the recommendation is being made and then 168A being applied, and where you sought for a recommendation and it was rejected, and then 168A is applied,
No, my lords, in
and
this,
then placed before the parliament under 166, which now takes the form of a secondary legislation.
my lordship, that's what, just if my lords can give me just 5 minutes, I will share the judgment that just because in a delegated legislation, a notification has to be placed before the parliament, that does not circumvent that if there's a delegated legislation and there's a condition prescribed to it, that does not ratify it.
We do one thing, Mr. Jain, we take it up tomorrow.
That will do, my lords, no difficulty. I will share those judgments.
Take it up tomorrow. The council appears on behalf of the petitioner, however, none appears on behalf of the standing council. You are a standing council? However, none appears on behalf of the CGST when a matter is called. Mr. B. Gogoi, you are there?
Yes.
Appears on behalf of the Finance and Taxation Department of the Government of India. Taking into account the above, this court adjourns the matter to be taken up tomorrow at the top of the list item. It is, however, made clear that if the CGST and the council, the standing council for the CGST is not represented tomorrow, this court shall proceed with the determination of the petition on the basis thereof.
Hello.
On the basis of the submission soon.
Okay.
Release item number 1 for motion.
Yes, what is this? As Burua submits that she could not obtain instruction taking into account their names have not been reflected. Yes, Mr. Burua. Your name is now,
My name is reflected, but I have checked from the office records. So government haven't been served with any copy from beginning.
Right.
Only the finance and revenue and water resource department have been served with copies. So we couldn't take any extra steps for taking the necessary instructions.
what is the case about, madam?
This land was acquired by the respondent authority in the year 2008 filer.
Acquired by whom?
Water resource department.
Water Resource Department. And they have not paid any compensation to you? Not a single penny?
And minor not yet proceeded.
Yes, what is it?
We have filed our definitive not.
What do they say? Did you acquire any land in respect to Goinadi left bank embankment?
Yes, Lordship. We have, Lordship. Dike has been constructed.
Huh?
Lordship. Dike has been constructed,
Did you acquire any land?
Lordship. Yes, Lordship, we have.
Did you acquire any land of the petitioner?
That is not confirmed, that is not yet been confirmed, Lordship, by the district authorities, Lordship. Because from the circle officer means joint verification report is yet to be submitted from the circle officer CC Borgaon, which we have.
But how can you take somebody's land for making a dike?
Is whether petitioner's land was there or not, we are not confirmed, Lordship. But-
Okay, petitioner's land, if it is there, remove that land. Then remove that dike and give it to the petitioner.
Lordship,
Give a direction to that.
dike has already been constructed, Lordship.
Break the dike
We-
for that portion and give it back to the petitioner. That is the only way out. Because you see, 300A is not, should not be there out there in the paper. Oh, that 300A is there, the constitution. For Water Resource Department, 300A holds no meaning.
We
We
acquired
keep this 300A provision in our pocket,
Lordship.
which is not to be seen in a black coat.
Lordship.
So nothing to do.
We have acquired the land as per the land availability report received from the means given by.
Land availability may be more.
But-
Tomorrow there will be a lot of land out there in Kharguli.
No,
There are a lot of land.
no, we
Why
don't,
don't you go and break all the houses out there?
Lordship, we don't acquire
You
land.
just take up the case of the persons like the petitioners and take advantage. Don't pay any compensation. Nothing doing.
No, we are not acquiring land directly, Lordship. We have been given the hand over the land by the district authorities only, Lordship. From the district authorities only.
District authorities give you the
Lordship,
land.
this deputy commissioner and the circle officer. Lordship. Until and unless circle officer gives the report regarding the availability of land,
A petition concern. No, I didn't know notice has been issued. That is the reason why.
you know, we.
Madam, I can't help you. Why haven't you submitted a copy to the DC? The issue notice making it returnable on 28th of August 2024. Pusto. Mr. A. Bhattaji appears on behalf of the Revenue Department and accordingly accepts notice on behalf of the respondent number 1 and 2. Mr. S. Borua appears on behalf of the District Administration, Dhemaji, and accepts notice on behalf of the respondent number 3 and 5. Mr. R. M. Das appears on behalf of the Water Resource Department
1 and 4.
and accepts notice on behalf of
1 and 4, Lordship.
1 and 4. He appears for respondent number 2. Eh? And Mr. P. Gogoi, where is he? I saw him somewhere. You are there. Mr. B. Gogoi appears on behalf of the Finance Department and accepts notice on behalf of the respondent number 6. The case of the petitioner herein is that the petitioners are owners of various plots of land. Situated at village number 2, Gormora, under Revenue Circle, Sessi Borgaon, under Moza, Sessi Borgaon. The lands of the petitioner, as alleged in the petition, have been acquired by the, have been taken over by the additional deputy commissioner have been taken over by the district administration, Dhemaji, for the construction of Gai Nodi left bank embankment. However, the petitioners have not been paid any compensation. Pursuant to an order passed on 19/6/2024, the respondent number 4 has filed an affidavit in opposition with a further leave to file a further affidavit in opposition. It is the case of the respondent number 4 that the construction of the Gai Nodi left bank embankment had already been made after the said land had been handed over by the district administration Dhemaji. Mr. R.M. Das, the learned counsel appearing on behalf of the Water Resource Department, submitted that the list of the beneficiaries who would be entitled to the compensation would be with the district administration Dhemaji. In that regard, a report was also sought for after making joint verification with the circle officer, that is the respondent number 6, respondent number 5. However, the said report is awaited. Have you paid the money to the district administration?
Lordship, till that we have not received the LA case estimate also.
Then how did you take out the land? This court put a pointed query upon Mr. R.M. Das, the learned standing counsel of the Water Resource Department, as to whether any payment of compensation has been made by the Water Resource Department to the district administration so that the district administration can make due payment to the beneficiaries. The learned counsel, to the utter shock and surprise of this court, submitted that the LA estimate from the district administration Dhemaji is yet to be received.
There was an emergency.
This aspect of the matter, in the opinion of this court, clearly is an infraction to Article 300A of the Constitution as to how, in as much as it is seen that the district administration, Dhemaji, have taken the lands of the persons without even initiating any process for acquisition. The above is completely the above action on the part of the district administration, if any, if is to be true, is in clear violation to the law laid down by the Supreme Court in the case of Kolkata Municipal Corporation and others versus Bimal Kumar Shah and others, delivered on 16th of May 2024, wherein the Supreme Court categorically holds that the right to property, though not a fundamental right, but is a constitutional right and encompasses the right to notice, right to be heard, right to a reasoned decision, with a duty to acquire only for public purpose, right of restitution or fair compensation, right to an efficient and expeditious process, and a right to a conclusion. Full stop. On the returnable date, the district commissioner, Dhemaji, is directed to file an affidavit as to whether the acquisition proceedings have been initiated, and before taking over the land of the petitioners, if taking over the lands prior to handing it over to the Water Resource Department, whether the mandate of Article 300A of the Constitution have been duly complied with.
Affidavit not received filed by the respondent authority on behalf of the respondent about
Madam, you do only one thing. Take steps, which I have directed. Rest, leave it to me.
Number two, the causes may also reflect GAS,
Not necessary. If you don't appear, we'll take it up.
because this is only by my name it appears. So normally the case gets missed.
Nothing doing.
Lordship, I'm extremely sorry. I have mentioned a matter 20 and 33.
Huh?
Actually, in morning, I have mentioned a matter 20 and 33. There was a submission on my part which is completely wrong, Lordship. Not full payment has been done. Part payment, most of the part payment has been done, Lordship.
Oh, in spite of that, then you
Lordship.
can't take it as adjournment. We'll take it as if full payment has been made as you submitted. Then we are not going to adjourn the matter. It's a
Because-
contempt. Ask those persons to be present.
It's a contempt and a
Because that
petition.
person came before this court
No,
when
that's
the
a
matter
different
was
matter.
there.
That's a different matter. That's an AP industry matter, Your Lordship.
Oh,
That
that is
payment has been
different.
made.
This is another one.
This is MSME matter.
Don't ask for an adjournment. Don't grant him the permission. Adjournment cancel. We'll take it up.
Very well.
Yes, who appears in this matter?
After the notification for acquisition of the land, petitioner has filed an application for considering zero compensation. So this has not been disposed of by the authority.
By whom?
The district commissioner, Kachar.
Competent authority is Kala.
Zero compensation, we have shown, the structure standing thereon. They have to consider it, and this subsection.
Your land has been acquired by whom?
By the National Highway.
National Highways Act.
That notification you will get it at page 12. And the petitioner's land will be at page 13.
Have you got the money?
Money has not been, I think it is in the process. But the Girard compensation, they are not considering it because they have not considered my application for Girard compensation.
So why should we entertain this petition?
So the objection has been filed within the time as stipulated in the notification.
So if they don't give it, then you have a revenue under 3G. Take steps.
Objection, they have invited my lord on the.
You have submitted.
Yes.
Have they come up with the notification how much you are entitled to?
No, that my lord, we came to know that the Girard compensation they have not considered.
No, nothing doing, Mr. Sir. Dismiss. Dismiss. No. You go there. If they don't give it to you, go under 3G. Nothing doing. This code is not going there. No, Mr. Counsel, if you are not going to get, you are not getting the adequate compensation, it is for that the act duly provides that. Why should this court take up all these things and then yeah?
ABC is not competent authority, my lord.
National Highways Act. We dismiss this. Heard Mr. B.D. Das, the learned senior counsel, assisted by so and so, appearing on behalf of the petition.
As per the notification, objection has been filed. And
You have filed the objection. If they don't take care of it, you very well have the opportunity under 3G. Take the steps. This code is not going to enter into this will be opening of floodgates unnecessarily. Wrong day. You have filed this matter. You should have waited for another 1 month. When I am not there.
my lordship is there.
Anyways, so dismiss. Dismissed.
Not dismissed, my lord. Your lordship directs for.
No, nothing doing. Absolutely no. Don't consider this court to be a postpone. Where is the National Highways Act?
I got a copy.
Nothing wrong. What will you do? Huh? You are kita. Hobo episode. National Highways Act complete. Heard Mr. B.D. Das, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner.
Approach your lordship. We can approach after.
To withdraw or dismiss. Let them also get some fees. Yes. With dismissal, I will. The fees for them. They let us also put their arguments up. Mr. A. Bhattacharjee appears on behalf of the Revenue Department of the Government of Assam. Miss so-and-so appears on behalf of the respondent number
2, 3, and 6.
2, 3, and 6. And number 4, Mr. S. Burwa appears for the respondent number 4 and 5. The petitioner herein has filed the instant writ petition. Seeking a direction upon the respondents to dispose of the appeal representation objection dated 13/3/2024 submitted by the petitioner by claiming Jirat amount within a specified period of time. It is seen from the records that a notification under section 3C Football, National Highways Act. What do you think it? PC was issued by the Ministry of Road Transport and Highways dated 2nd of February 2024, calling for objections to the use of the land for the purpose mentioned in the said notification. In the said notification, the land belonging to the petitioner have been duly mentioned. The petitioner thereupon submitted an appeal to the District Commissioner, Kachar Silchar, claiming, though not opposing the acquisition, but claiming that the Jirat amount compensation should be included while determining the amount in terms with section 3G of the National Highways Act 1956. This court had put a specific query upon the learned senior counsel as to whether any determination has been done of the compensation by the competent authority so appointed in terms with section 3 small a of the National Highway Act 1956. The learned senior counsel duly submits that the said determination is yet to be done, but the petitioner apprehends that its Jirat value shall not be taken into consideration. Taking into account the said submission, it is the opinion of this court that the instant writ petition is not only premature, it is a premature writ petition. In addition to that, it is also the opinion that if the petitioner is aggrieved by the amount of compensation, the petitioner duly has the avenues, remedies, an efficacious remedy in terms with section 3G 5 of the National Highways Act 1956. Accordingly, this court, therefore, is not inclined to entertain the instant writ petition. Be that as it may, this court, however, observes that the competent authority, while determining the compensation, shall duly take note of the provisions of section 3G of the National Highways Act 1956.
After determination, you will be free to go.
I always give you. I gave you the relief what you want.
So second is also same, only the classification of the land could have been made commercial instead of same land, same petitioner.
Mr. Das, you have filed an objection against the 3C.
Hello.
3C is limited. 3C is only that you have objection, whether you have an objection to the acquisition. And number 3, same order.
For classification,
It is Jirat Nagar, yeah, appending the classification to it.
to be as a commercial. Okay. For The commercial classification of the land as a commercial land should not be taken into consideration. Agote has submitted a representation that his land should be taken as a commercial land. Huh? Yes, what is this? What is?
Were allotted a plot of land of 75 bighas for the tea plantation. Thereafter, the revenue records were corrected to that effect, and while handing over possession, it was found that there were encroachers who have been encroaching the land. an eviction case was initiated by the government. Against that, the encroachers came up before this honorable court in a challenging the eviction case, and there was a stay. Subsequently, that eviction case, the petition was disposed, directing the authorities to take into consideration the application pending before the authorities for allotment in respect of those petitioners. And till that time, pending disposal of this, the applications, they should not be evicted, my lord. Thereafter, my lord, we filed an application, petition 2811 of 2010. My lord will find the order passed in that petition. Page 83, my lord. This is a common order. One petition filed by the petitioners and the other by the encroachers, my lord.
Yeah, what is it?
My lord, in that petition, the encroachers took a stand that they are not occupying the land that was allotted to these petitioners, my lord. And therefore, the honorable court at page 88 directed to hand over possession of the land allotted to the petitioners. Page 88.
To you.
To us.
What, this is a ceiling surplus land or what?
The land, it was allotted, my lord, to this society, my lord, for tea plantation.
What society? Oh, that petitioner society. Then?
And the revenue records, everything was corrected, my lord. While handing over possession, it was found by the circle officer that there are persons who have been encroaching this plot of land. Eviction case was initiated. That eviction was put to challenge before this honorable court. Honorable court did not interfere with the eviction. However, directed the authorities to take into consideration the application of the encroachers for allotment. And till that time, they should not be evicted. Those applications were disposed. Subsequently, when we filed a writ petition, we were never a party in that writ petition. We filed a writ petition claiming that we have to be handed over the possession in terms of the allotment order. There was another writ petition by the encroachers. They did not contest our writ petition. On the contrary, their stand was they are not occupying the land that is allotted to the petitioners. Page 88, your lordship will find the direction in the petitioner's writ petition.
Then what happened?
Then, my lord, a contempt case was filed. During the contempt case, my lord, the circle officer claimed that the land has been handed, the possession of the land has been handed over to us. We protested, we filed a protest application saying that the land which was allotted to us was not handed over. Subsequently, my lord, there were certain communications between the authorities with regard to the possession. Then your lordship will find page 107.
Then what happened? Possession handed over or not?
No.
What is this impugn order?
The impugn order, my lord, the deputy commissioner now, based on this objections, has passed this order 18/8/2022. Whereas
Yes.
the
Whereas the third paragraph,
third paragraph.
resident of so-and-so had formally taken over the possession of the land. Subsequent to the judgment of the Honorable High Court, dated demand by signing the certificate of taking over of possession, but they failed to retain the possession of the aforesaid land till date, and the said land is under the occupation of so-and-so and so-and-so. Where it has been revealed from the report of the aforesaid schedule of land comes within the tribal band, and neither the members of so-and-so nor the encroachers of so-and-so belong to classes of persons notified under chapter 10 to acquire in possession of the land. Now therefore I submit, I see so-and-so direct the circle officer to make the land in possession by allotment in favor of landless persons in the provision.
But the person who has been shown to be occupying are the same encroacher, my lord. If your lordship will kindly find page 109. It's the report of the circle officer. They have identified at page 1110 the name of the persons who are occupying the land which was allotted to us. These are the same persons who have been earlier identified as the encroacher and who claim that they are not occupying our plot of land.
Now your thing has been cancelled.
It has been cancelled.
Why haven't you approached the Board of Revenue?
Well, if your lordship will kindly find
Because the settlement has been made by the government. Oh, why is it cancelling? The
Well,
deputy commissioner.
the deputy commissioner's cancellation on two grounds, my lord, that we fail to retain the possession. My lord.
Yeah, that is one thing. We are not
And
concerned.
the other is that the land, the persons belonging to the petitioners are not the classes under the chapter 10, my lord.
You are
and-
not
and
scheduled
therefore-
right.
But this is contrary to the report of the additional deputy commissioner, which was given prior to the allotment. My lord will find at page
So you have
28.
taken the allotment by practicing fraud.
No, it is the deputy commissioner's own report at page 28, my lord.
Hello? We have to
Chapter
issue
10 is
only.
not applicable at all, my lord.
Huh?
Chapter 10 is not applicable because the persons who are the petitioner, the members of the petitioners association, they are the permanent resident of that area, my lord. And there is a report of the additional deputy commissioner which was prior to the allotment. And based on this report, after examining everything, the allotment was given
By the government.
by the government. And page 28, well, it's a categorical report by the additional deputy commissioner.
So what do you want now?
But at this stage, my lord will issue notice and my lord will suspend the operation of this order, my lord. The order by the deputy commissioner, but because my lord, the petition, my lord, the circle officer claims that they have handed over position.
Why were you sleeping for 1 year, in 10 months? 11 months?
My lord, they were the petitioners, my lord, they were pursuing with the circle officer with regard to handing over possession, my lord.
But
Subsequent,
after passing of this order was also marked to the circle officer. Then why were you pursuing with the circle officer?
order was not passed to us, my lord.
Okay, but it was given to the circle officer.
Circle officer.
When
We
did
were
you come to
pursuing
learn?
with the circle officer for
When
handing
did
over
you
possession.
come to learn about this thing, about this order?
Technically, my lord, we have not rejected.
Huh?
Eighth, my lord, we have not stated when it is.
When you have come to learn about this order? Nothing mentioned. Hello, we issue notice, nothing more than that.
But if your lordship will kindly appreciate one thing, my lord,
I
page
cannot
1,
appreciate any further thing. I am issuing notice on a belated repetition is what you should be happy about.
but apparently from page 109, your lordship
I
will
am
find
not going to look into all other things. This is a case of delay in latches on the face of it. You were given the possession, you could not take.
No, my lord, in fact, it was claimed that we have been given a possession, my lord, there is an immediate.
Why
on
you are not
13th
challenging? You cannot challenge it there because it is too delayed before the Board of Revenue.
Your lordship will kindly
You
find.
see,
page 90, my lord.
tell me one thing. The possession having been handed over, that is what have been stated to you. And then they will say the possession has been handed over, he could not. What will this court say?
My lord, they claim that the possession was handed over on 24/6. 25/6, my lord, we have submitted our objection, my lord, on page 90. That the possession which has been shown to be handed over by taking signature of some of the members in the.
Anyways, we issue notice, nothing more than that. Yeah. But Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner. Mr. S. Doctor appears on behalf of the respondent number 1 and 2. Mr. S. Borwa appears for respondent number 3, 4, and 5. Mr. Taking into account the respondent numbers 1 to 5 are duly represented, extra copies of the petition will be served upon them during the course of the day. As regards the respondent number 6, petitioner is directed to take steps by way of registered AD with AD as well as usual. In addition to that, the petitioner is also directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the date. Issue notice date to issue niki. So issue notice making it returnable on 2nd of September. The case of the petitioner herein is that the plot of land measuring 75 bighas covered by Dag number 1 of village Gorubanda. What is that? Tramjuli. TRAMJULI under N. Dot Khezakhat Moza of Narayanpur Revenue Circle was allotted in favor of the petitioner society by the government letter dated 24/4/2001. However, while granting the allotment, the possession of the land was not handed over. It is the case of the petitioner that this court, by an order dated 5/2/2013 in WPC number 2811/2010, direct handing over of the said plot of land to the petitioner, directed the revenue authorities to hand over the said plot of land to the petitioner. In spite of the said direction, there was no compliance, for which a contempt proceedings was filed. It is the case of the petitioners as submitted by Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, that behind the back of the petitioner, the impugned order was passed, whereby the Deputy Commissioner, the Lakhimpur, had held that the petitioner was handed over the possession and the petitioner could not retain possession, as well as have also cancelled the allotment which was made in favor of the petitioner by the government of Assam. He submitted that the members of the petitioner's society are all permanent residents of the said area. And as such, the provisions of Chapter 10 of the Assam Land and Revenue Regulation 1886 shall not bar the allotment so made in favor of the petitioner. He further submitted that the allotment was made in favor of the petitioner by taking the said aspect of the matter, had allotment made in favor of the petitioner on the basis of the said report being submitted, which was not taken into consideration by the learned Deputy Commissioner in the impugned order. He additionally submits that if the impugned order dated 18/8/2022 is not stayed, the respondent authorities would allot the said land to third parties, which may create third-party rights and accordingly complicate the issues. I've heard the learned counsels appearing on behalf of the petitioner as well as the respondents and have given an anxious consideration to the aspect. It is seen from the order passed by this court dated 5/2/2013 that there was a direction passed by this court to the respondent authorities to hand over the possession of the land to the petitioner. At that relevant point of time, there was no objection raised as regards that the petitioner would not be entitled to the allotment. The question as to whether the petitioners were handed over the possession and the petitioner could not retain the possession can only be decided upon getting to know the stand of the respondent authorities. However, it is the opinion of this court that if third-party rights are created by making allotment as directed by the impugned order dated 18/8/2022, it would
further lead to multiplicity of proceedings. Accordingly, this court directs the district commissioner, Lakhimpur, as well as the circle officer, Narayanpur Revenue Circle, not to initiate any steps for allotment of the land which was previously allotted to the petitioner.
Grateful.
If it has not yet been allotted. Already.
So item number 5, 6, 7 are the similar method, and another 5 methods are there. And filing number I have, but that is not registered here. However, my lord, the item number, if I start with the item number 5, the matter like that, land was acquired, portion of land was acquired by the highway authority. There is no dispute regarding the land compensation, but there is a dispute regarding the building. Each cases there were building, part of those were acquired, but the remaining part were not considered. Therefore, I have filed petitions before the arbitrator. At that time, if the office was at Durham. And accordingly, the
Mr. B. Gogoi, who is in charge of the special secretary to the government of Assam? Arbitrator?
Lordship, Lordship, there's a gazette notification published by the published Lordship, and the special secretary, sorry, Lordship, that arbitrator is Lordship, one Lordship person, namely Lordship Ashok Kumar Burman, Lordship.
Yes.
There is a similar order, Lordship, passed by this court, Lordship.
By your lordship.
I pass.
No, Lordship, another court.
And there are total numbers of 16 petitioners and all numbers 25 of the 24, 22. Earlier, these 3 persons came before this honorable court. Madam. Remaining persons have just come up.
No, Mr. Counsel, this order, wouldn't that suffice? Because this is an order passed in the same arbitration case.
Correct, but problem is that each reports are different. So the reports prepared by the Kala or the PWD for each building are different. So individual direction may be required to get those all cases. Otherwise, what would happen, my lord? They will put up only these petitions, not
Huh?
other petitions.
What is this?
But-
How can that be? Each arbitration will have a different number. What are you going? What are you doing? You are the National Highway.
Yes, Lordship.
You've taken things for right. How is this possible that everybody, just for example, one person wants to challenge it? How will he challenge it? An arbitration award under 34?
Lordship, since arbitrator has been appointed, Lordship, his prayer is to Lordship issue direction to special secretary to dispose of the matter, Lordship.
Understood.
Yes.
But why do you require for each person to come up before this court and file a
That is
petition?
not, that is
Unless
not,
it
Lordship.
is a thing
That
that
is
the
wrong
council
submission, Lordship.
wants that every petitioner should also get a similar
No,
order.
Lordship, that is wrong submission, Lordship.
The
That is,
problem is
that is
that
wrong
that is
submission,
what
Lordship.
happened.
Huh?
That is wrong submission, Lordship. The arbitrator, since arbitration have been appointed, Lordship, he will dispose of the matter, Lordship.
Understood. When there is already a direction in
Lordship.
arbitration
Yes,
case,
Lordship.
where is the question of every petitioner coming?
Lordship, there is no question from the part of the respondent authority, Lordship.
My goodness.
But that is what happens.
Don't come up with all these things.
Because, my lord, when
I
the
will just
petitioner-
write one line. That the orders to be passed in the instant petition is covered by the directions passed in Swins.
Yes, that is-
No.
But yes. May I pray for one thing, that report should be given to immediately. That report, otherwise I am having trouble that I cannot demolish the building because I did not get that report. If that report covers me, the entire building, I can demolish the,
That will be decided by the arbitrator.
more than 1 year passed. No report has been provided to me by the Kala or PWD, arbitrator is not there. The Kala or PWD would provide me that report. I have filed applications before them also, but they say that as because we send it to the.
Now there is an arbitrator.
That, my lord, portion may be given, that arbitrator should provide immediately.
We do one thing. Normally I'm supposed to retire in year 2035. Keep this matter pending. Let me be the arbitrator. My goodness, is this the court is going to deal? What does section 17 of the Arbitration Act have to do? Why are you not moving the arbitrator for that? Asking for the report under section 17?
The office is not yet there.
Then there is an office.
More than 1 year
Yes,
passed.
already lordship that name or arbitrator has been
Recently.
appointed and name in the.
Yes,
order.
yes.
The charge is not yet given, my lord. I
No,
have,
no, there is another direction passed. Where
There
is
is a
Mr.
direction,
Silva is not, nowadays
Lordship,
not
there is
there.
a direction that within 12 months he is to dispose of all cases.
my lord,
Yes,
I can
no,
assure you, lordship.
Mr. B. Gogoi, you were representing in that earlier matter, if you remember. There was a review petition filed.
Lordship's initiative, this has been done within a.
Yes, because of me, this has happened.
That is correct, my
Then-
lord. But the problem is that.
How can they be every time? No, everything is a
files
repetition.
are
there.
not yet
These
clear,
are the
my lord.
repetitions. One line order, nothing more than that.
Yes.
These petitions
Five,
are not
six,
fit
seven.
for anything.
Another files are coming up actually.
Huh?
Actually, my lord, may kindly come to page 17 of the section total 16.
Any
petitions.
more petitions comes out here before the court is a case of cost. Withdraw it before the registry itself. My goodness, everybody coming out here. So beginning. All are same.
My lord, in that case, my lord may specifically provide that case number 25/22 should be taken up together. All
What the hell
cases, total 16 numbers.
I will
Individual
do one
petitions
thing.
are there.
Which are the items? 5, 6 and 7.
Now, and otherwise list is there.
Mr. Your
Yes, sir.
name, give me your name.
TK Nath.
Mr. D.K. Nath, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukdar
For seven,
appears on behalf of the respondent numbers.
7, my lord.
Respondent number 7.
Yes, please.
7. Appears on behalf of the National Highway Infrastructure Development Corporation Limited. Pusto. Miss Union of India. And so appears on behalf of the Union of India. And Mr. B. Gogoi appears on behalf of
3 and 6.
3 and 6. And Mr. S. Dotto appears for respondent number 2. All are same. Respondents in all the petitions are same. Yes. You make photocopies, no require for printing out there. And Baki Gita, it appears on behalf of the District Commissioner S. Borwa. The petitioners in the instant 3 petitions, pursuant to filing applications under Section 3G of the National Highways Act, seeking enhancement of the compensation, the competent authority have referred the matter for arbitration. Full stop. Taking into account that the government of Assam in the GAD department had nominated the special secretary to the government of Assam, one Mr. Ashok Kumar Borman, to be the arbitrator in terms with Section 3G 5. All these arbitration proceedings filed by the petitioner in the 3 petitions have been conjoined together in one proceedings, that is arbitration case number 25/2022. It has also been submitted by the learned counsel appearing on behalf of the petitioners, that in addition to the present petitioners who are before this court, there are other petitions also which have been conjoined and taken up together in arbitration case number 25/2022.
Page 17 list is there.
During the course of hearing, the learned counsel appearing on behalf of the respondent number 7, Mr. R.K. Talukdar, has placed before this court that there is already an order passed by a coordinate bench dated 29/4/2024 in WPC number 2239/2024, wherein there is already a direction passed direction to the special secretary to the government of Assam, who is also the arbitrator, to dispose of the arbitration case number 25/2022 within a time-bound period as prescribed under section 29 capital A of the Arbitration and Conciliation Act 1996. Under such circumstances, as there is already a direction which have been issued, this court is of the opinion that a similar direction can very well be issued in the instant proceedings. Who is in charge of this arbitrator? JD.
It will be JD. Files are with revenue, I think.
Revenue.
Yes, it will be revenue.
Gazette
Files are with.
I've asked them to have an office. There's an office.
There's the office.
Where?
Assam Secretary, all same block, Assam Secretary. All same block. Within bracket I.
Huh?
There is an office already established, in the secretariat. Assam
Where?
Secretariat. All same block,
Old CM block,
ground floor.
office of the special secretary, come arbitrator. It has been submitted by Mr. S. Dotto, the learned counsel appearing on behalf of the revenue department, that the arbitrator in question have been already allotted an office and he maintains his secretariat from the old CM campus block.
Assam Secretariat.
Assam Secretariat.
Ground.
Ground floor. Taking into account the above, this court directs the petitioner's hearing. You have submitted your claim petition?
It's already there. Those are already there, madam. Against which
Have
report was
the other side filed replies?
Yes.
Taking into account the above, this court also issues similar directions to the arbitrator. How can this court direct when the arbitrator is not here? He's not a party to the proceedings?
Judiciary, he is holding the judiciary post, so I should not make him as a party.
What? Whom should I issue a writ?
Hello, this,
At the point of time when you made this petition, then arbitrator was not there.
is also correct.
Now arbitrator is there.
Allow me to be represented before him. Thereafter, he can take my matter. That direction is already there. my lord.
কি লিখে last line to? Taking into account the above, this court disposes of the instant petition, observing that the arbitrator who is in session of arbitration proceedings being of the arbitration proceeding being arbitration case number 25/2022 is required to take steps as prescribed under section 29A of the Arbitration and Conciliation Act 1996, taking into account subsection 6 of section 3G of the National Highways Act 1956. With the above observations, the petition stands disposed. Next matters comes is a case of cost. Withdraw it there, unnecessary.
One case is not there.
Before your lordship that the patent of Gangapur village mine. Schemes are approved without holding any cows of office. Or subsequently for the sake of the development of the village, the petitioner raised no objection mine. But as gross anomalies are committed by the thereafter, after observing all these things, several representations are submitted before various authorities. But in spite of those representation, no action has been taken by them. The next representation starts from page number 12.
Yes, tell me.
My lord, lordship, inhabitant of Gangapur village of Kasar district, my lord, 3 schemes were approved by the authorities, my lord.
Huh?
For development of this model village were approved by the authority without holding any house of Baba. Initially, though these are approved without house of Baba, the inhabitant has not opposed, my lord. But after that, those anomalies are committed by the authorities in implementing the schemes, my lord.
Who have not done it?
My lord. Whatever, lordship.
There is somebody who? Your complaint is you are making allegations against somebody before the authorities. Who are those?
My lord, order was passed by the deputy commissioner, my lord.
Against allegation against whom?
My lord, in some case, my lord, JEO allegations are against the, my lord, authority.
Huh?
Against my lord.
Here it say administrative approval sanction is hereby accorded for implementation of the following schemes under the Assam Adarsh so and so. And so is hereby released to the implementing agency. That is the member secretary construction committee under the Assam Adarsh so and so. Okay? Chalo. Now, where is the member secretary of the Adarsh construction committee?
I have not done it.
Huh?
I have not.
Then your representation is also not clear. File a proper representation. What they are not doing, who are these people model?
My lord,
You can come up with this repetition. Only was sanctioned for so and so, sir. No proper work has been done, and also above. Moreover, so who has not done the work?
So there, my lord, the construction committee.
None. They are not a party out here. We dismiss it.
I may be allowed to increase.
Withdraw. Withdraw. And your representation has to be specific that these people are not doing it.
In that event, my lord, I may be allowed to file a representation for the authority, my lord.
You give whatever you feel like.
My-
The learned counsel appearing on behalf of the petitioner submits that he would, that there is a formal defect in the instant petition, taking into account that the construction, the implementing agency have not been made a party. In addition to that, the learned counsel submits that from a perusal of the representation, it is not clear as regards the allegations. In addition to that, the petitioner submits, he therefore submits that he may be permitted to withdraw the instant petition. Taking into account the above, the instant petition stands closed on withdrawal. It is, however, made clear that if the petitioners are aggrieved, they are always at liberty to approach the appropriate forum, appropriate authorities, taking redressal.
In such event, my representation,
Ah,
in the event of filing any representation before the authorities, that may be considered within a period of.
we'll see.
Alright.
My lord, originally, my lord, there is a plot of land.
Liberty, however, is given that move this court if the representation so submitted is not duly redressed by following the duties. Yes. Yes, what is it?
My lord, there is a plot of land measuring 3 biga 1 kata 12 plaza. That particular area of land, my lord, owned by was Saimuddin Sheikh. And from that land, my lord, we purchased, the father of the petition number 2, purchased 1 biga 2.5 plaza in the year 1966. And since then we are residing there. And on the other hand, my lord, petition number 1, he has purchased by sale with my lord 3 kata 6 lasa in the same, my lord, same dark patta, my lord. The total land of petitioners now, my lord, they are residing by constructing their dwelling houses 1 kata 2 lasa 4 lasa in total.
1 biga 2 kata 4 lasa.
Now, my lord, you lordship kindly see the land of the private respondent. Private respondent, their mother, Toyoba Khatun, she purchased only, my lord, 1 biga 4 kata 8 lasa from one Sridhan Pal in the same Dakpatta, my lord. And now, my lord, in the year 2021, some portion of the land measuring 64 lasa has been acquired. Now, my lord, we have come to know that regarding this land, in respect of this land, 1 crore 22 lakhs something, my lord, has been assessed. My lord, in the name of the private husband. On the ground, my lord, since, my lord, we have purchased the land in the year 1966 by registered sale deed, that has not been mutated. That is the ground. And on the other hand, petitioner number 2, he also purchased the land by registered sale deed. My lord, his name has been mutated. Now, my lord, in the year 2022, his name has been struck down. Your lordship kindly see, very unfortunate, my lord. Now, entire amount has been assessed in the name of private respondent. In fact, my lord, their land is only, my lord, 1 biga 4 kata. Admitted fact, my lord. Your lordship kindly see, my lord, my petitioner number 2 has been struck down. Page 28, my lord. In fact, my lord, we are residing by constructing house there since 1966. My lord, comment your lordship kindly see. As per order dated, page 28. As per order dated 26/1/22, land has been acquired 22. Passed by the circle officer in so and so, pursuant to an application filed by the regulation of private respondent. The name of the patta, the Subhash Chandra Bose, is hereby cancelled. How can I? Now, my lord, your lordship, we filed an objection. Objection hearing conducted. Objection hearing conducted by one
land acquisition officer in the office of the respondent number 4. My lord, what happened, my lord? With the moment, my lord, our objection stopped. As on the ground, my lord, your name has been mutated, your petition number 2 has been struck down. That's why my hearing stopped. And openly he told us, my lord, entire compensation will goes to the private respondent. Since his name has been mutated, his land my lord only 1 biga 4 kata 8 lessa. How can he get entire land, my lord? Now, my lord, my submission before you, lord.
This acquisition is done under what provision?
My lord,
This acquisition is made under what provision?
my lord, we have filed application, my lord. Application objection hearing conducted. And in the openly, the land acquisition officer told, no, you will not get compensation as because your name has been struck down. And 1996, my lord, we have registered sale it purchased the land that has not been made on the 2 ground, my lord. Now, my submission, my lord, the objection hearing should be conducted by the respondent number 4 district commissioner. And till then, my lord, the huge amount, my lord, 1 crore 22 lakhs and something, my lord, award number 54, that has been stopped, my lord. Otherwise, we will be prejudiced, my lord. My lord, land was acquired in 2002. My name, petitioner number 2, has been struck down in 2002. How can, my lord, we are residing here?
Your land was acquired in 2000?
2, my lord. In LA case number 2001/2021-22.
So the acquisition was made in 2022.
2, my lord. In LA case number
Is it in 2002 or 2022?
21/22. In fact, my lord, it is admitted, my lord, private respondent also residing there by constructing their house. It does not mean, my lord, he will get entire compensation. From roadside, our land has been acquired. Our roadside, his land also acquired. Our land has also acquired. His land portion is 1 biga 4 kata. Our land portion is 1 biga 2 kata 4 lasa. That land has been over that particular land. We are residing 1966 by constructing dwelling houses. My petition number 2's father died. Now, before you lordship, his son, my lord. You lordship kindly see the my lord, patta, my lord. My lord, I have annexed everything, my lord. My lord, annexure 1 is the my lord, original, my lord, land. Page 18, my lord. 3 biga 1 kata 12 lassas. That originally owned by one Soimuddin Khaik. From that, my lord, we have purchased, my lord, page 21, my lord. Page 21, my lord. Jagadish Pal purchaser, my lord. Jagadish Pal, father of the petition number 2. Manoranjan Pal, uncle, my lord. Sunil Kumar Pal, all are uncles, my lord, of the petition number 2, my lord. Land measuring, my lord.
Who is the petitioner number 2?
Petition number 2, my lord. He is my lord Sunjit Pal, my lord.
What right he has?
My lord, his father's purchased the land.
Huh?
His father purchased the land.
Father is dead or alive?
Dead, but already died. Already died. Already died. And
Yogesh Chandra Paul.
yes,
But his name was never there in the patta.
my lord, originally land was purchased by his father. His name has not, father's name also not mutated. His name also not mutated at the present time. Now on this ground, my lord, our land compensation cannot be lost, my lord. My lord, mutation does not acquire, my lord, right title, my lord.
Very, very short notice.
My lord, only my submission,
Only
my
to
lord.
know.
My humble submission.
Only to know as to under what provision. If I know the provision, whether it is done under the right to fair compensation or if it is done under the Assam land acquisition and requisition, the moment I come to know, the matter is disposed of.
My lord, you lordship
Only
kindly see the
limited instruction.
notice, my lord. Notice you lordship kindly see page 33, my lord.
Issue notice making it returnable on
In the meantime, my lord, payment may be held up, my lord.
21st of August 2024. Mr. Union? No. Nobody from the Union of India. NF Railway, nobody. Who are you? You're
I'm
standing
appealing for
counsel.
one- No, on behalf of Mr. S. K. CCC.
Where is he?
S. K.
Where is he?
He's coming to court now, but
Huh?
now he is not in the court. He is coming to the court. Present.
Now he's not in the court means?
He's coming from Aizawl.
Get hold of another one. Did you see Mr. S.S. Roy today?
As Burwa, Miss as Burwa can also.
Mr. S. Bolwa is there, na? Okay. Today she is there?
Yes.
Ms. S. Bolwa appears on behalf of the respondent number 1 and 2. Mr. S. Dotto appears on behalf of the respondent number 3. And Mr. S. Bolwa appears on behalf of the respondent number 4. Taking into account that the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 5 to 8, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. In addition to that, the petitioner is also directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein claims to be owner of a plot of land measuring 1 biga 2 kata 4 lechas covered by Dag number 36 old 59 new or Patta number 17 of what village?
Revenue village, Hakama part 2.
Of village Hakama part 2, Porgana Khutaghat
Under Bilasi para.
under Bilasipara Revenue Circle. Full stop. It is the case of a petitioner that in respect to land acquisition case number 1/2021-22, the respondent authorities, more particularly the respondent number, more particularly the respondent number 4 is not inclined to hear the case of the petitioner on the ground that the land of the petitioner, in respect to the land in question, the name of the petitioner had not yet been mutated. It is not mutated. It is the case of a petitioner that the petitioners have due documents in respect to the land in question. And merely because mutation has not been done, that cannot deprive the petitioner of their rights over the land. In addition to that, the Land Council submitted that even that as the petitioners are in possession of the land in question, they come within the ambit of person interested. And as such, the respondent authorities, more particularly the respondent number 4, cannot deprive the petitioner of the compensation in respect to LA case number 1/2021-22. The Learned Counsel for the petitioner further submitted that in the instant case, the respondent number 4 is inclined to grant the entire compensation in favor of the respondent number, in favor of the private respondents. And in such circumstances, it would be very difficult later on to get the money back, to realize the money once it is being released. This court had duly taken note of the documents enclosed to the writ petition and is prima facie of the opinion that till the next state, the the amount of rupees 1,22,65,288, which have been sanctioned in respect to the land,
What number?
in respect to LA case number 1/2021-22,
Number 84.
in award number 54 pertaining to the land covered by DAG number 36 old/59 new, comma, patta number 17 of village, village ekita likhi dibo, ha? Village ekita agote koisu na, be withheld by the respondent number 4. Full stop. This court further directs the district commissioner, further directs the respondent number 4 to apprise this court on the next returnable date as to under what provision the land have been acquired. The moment I come to know about the land, you are relegated.
Obliged, my lord.
Item 10.
Obliged, highly obliged.
Yes, Mr. Agustami.
Lordship, this is non-reimbursement of the my lord, total
Pay
cost.
the insurance claim amount of the petitioner immediately and further to appropriate action if illegality have been committed by the said respondent as so and so, they are paying the amount.
Total cost is about 7 lakhs, my lord. Page 73 is the, my lord, last representation submitted by the petitioner on 15/3/2024. Here, it appears. that, my
Page?
lord, Page 73.
Did you go to the insurance ombudsman? You went. Why?
Because they have paid only rupees 1 lakhs because it is robotic surgery. Robotic surgery was made in Manipal Hospital in Millard, Bangalore. For that, Millard, they have paid only rupees 1 lakhs out of total rupees 7 lakhs because their policy is for last 43 years. They have paid 70,000 per year. They have paid only reimbursed only rupees 1 lakh.
Then why you are not going to various things, just for example, the Consumer Protection Act or the insurance ombudsman, why you are approaching this court? At the end of the day, you may lose a lot, Mr. Raya, because this matter will get delayed. You need an early, and that I think the 2019 Consumer Protection Act would be more beneficial for you.
Because she will have to go to the consumer court, my lord. She is not in a position to move now.
He does not need to go. It has to be only by way of filing an application.
It can be
If
done.
she can file an application before this court, why not before which one? In Kamrup Consumer Forum, why they are not asking for that? It will be easier nowadays. It is time. There are a lot of powers being given nowadays with the 2019 Act.
Yes, sir. Amendment, recent amendment.
No, this petition at the end of the day may, if it goes for another 2-3 years, it is not going to serve your purpose.
In the meantime, there may be some, my lord, because the court and the national insurance company, my lord, sometimes due to the, my lord, national this compromise may be made.
No compromise, nothing happens out there. Why don't you move the insurance there or out? I think the consumer is the better. Now, with the 2019 amendment, it has got a lot of teeth. It will be more beneficial for you, and there is a time period within which it is end. Here, what can I do at best? I can issue notice, and at the end they will come up and file affidavit. Hearing, can it be looked into as to how much you are entitled to? Hope is very less.
Consumer court also, it takes, my lord, lot of time because.
No, nowadays, I think it's less.
No,
Or approach the insurance ombudsman. So they are bound to follow the insurance ombudsman. They are faster.
later on, if it's necessary, I will draw now only let the notice may go. And I'll advise them to approach the consumer court or
No,
the
you can't approach both forums. Nah? Here, if you are here,
after withdrawing.
that
if
you
they-
you can very well do. And who is number 2?
Same, my lord, says divisional manager.
Why you are making her by name?
By name, my lord.
Why you are not making the divisional manager a party?
Divisional. Party Quorum. Yes, my lord. The application was submitted to the divisional manager, page 73.
Understood. Why you are not making a divisional manager party? Why you are making that person by name a party? He is not a private respondent. Then you do one thing. You have not specifically referred to as the petitioner respond number 2. You file a fresh memo parties. Fresh memo parties. Whereby have only one respondent. So and so represented by having its main office. Then say that has also an office at Maligaon represented by the. I think that is a better option. Mr. R. Goswami, the learned counsel appearing on behalf of the petitioner, submits that he may be given some time for filing a fresh memo of parties, taking into account that the respondent number 2 have been unnecessarily arrayed. This court also have perused the instant writ petition, and there is no specific allegation against the respondent number 2. Accordingly, this court fixes the instant writ petition again on 5th of August 2024. In the meantime, by 2nd of August 2024, the petitioner will file the counsel for the petitioner will file a fresh memo of parties. The registry shall, on the basis of the fresh memo of parties, make necessary correction in the cause title of the writ petition, as well as also update the same in the CIS.
11.
Yes, Mr. B. Sharma. Why were you not there when the railway matter is there?
New matter, my lord.
Motion matter.
I do not appear in the new matters, my lord. I'm appearing on
Oh, you are an old person. Okay, very well.
new matters. The CGSC panel, counsel from the CGSC panel, they appear.
No CGSC, nobody was there. Anyway, chalo. Okay. Yes, what is this?
In substance, basically, we're praying for a response from the Power Grid Corporation. Although there have been many favorable considerations, nothing has been properly said. It so happened that there was a taking over of the NSPC by the Power Grid, and we were working then earlier, and subsequently they were not working. Several petitions were filed, all taking into consideration the basic things and seeking a response from them. Since the matter was kept in the loop, nothing forwarded. Now, at least at the back end of life and service, not if they just give
Why will they absorb you?
matter of whether they absolve us or not, they proceeded on this premise to be absolutely fair. That initially it was not even granted to us. You have a right to be absolved, number one. Subsequently, as a petition proceeded differently numbered, there was a time 2005 something onwards that it says that so far as your claim is concerned in this region, that stands defeated. But in other parts, of course, there can be a door open for exploration. In the petitions to follow, they came up also jointly that in grade 3, grade 4 posts, of course, if avenues are there, it may be proceeded. Subsequently, the hope was always there. Of course, it did not see the light of the day.
eventually what happened is that they came up with a standard, no, before you came up with the writ petition, particular writ petition, if I may say, we had come up with a recruitment. So your order comes in way when we are in through this. So therefore, possibly age relaxation, all these things would not come into play. At that point, what figures is that litigations were on since long, until the recent past. And their stand is that they had
What is your right to be absolved?
not the right to be absorbed.
Then that is
But so far as
dismissed.
so far as they
Lordship,
are
earlier
concerned-
occasion also they have approached this
Absolutely.
court, and Lordship, thereafter they went to the Supreme Court also, Lordship. Page 51 order reflect, Lordship, that also
Where?
dismissed, Lordship.
So I
Page
can-
51, Lordship.
point
Huh?
out the directions, my lord.
Lordship, time and again, they're coming court and
Ah.
page
Where,
51,
where?
page 51, Lordship. In
Page
the order, it is reflected, Lordship.
61,
51, 51, Lordship.
51.
And at present, they are not working also, Lordship.
Considering the facts and circumstances stated, there is no scope for this court to issue a direction in the matter. So and so, petitioner referred an appeal.
Middle portion, Lordship,
Lordship.
SFPD, Lordship.
Were given 2 weeks. Then, huh?
Say 70,
70,
Lordship.
yes.
In that case also similar, Lordship, third line. This court has also not recognized any right of the petitioners to re-engagement in the earlier proceeding, and discrimination of the authority to re-engage the petitioner not being founded or relevant excellence. I do not find any good ground to allow the relief read for the repent they will dismiss, Lordship.
10 petitioners.
So initially, the lot was that 41 numbers were there, 9 were there, the less were not. So
Some petitioners here in this case also. Here in this case also some petition, that is petitioner number 5 is at present proceeding, Lordship.
Chalu.
Page 61.
thereafter, we
Okay, okay, we dismissed those petitioners who were there earlier with cost of 50,000 each.
Lordship, case page 1579, Lordship takes the point.
Which are the petitioners who were there 50,000 each? Huh?
For example.
Come up with this type of petitions. Yes,
This was in 2013.
Lordship, that order,
The-
Lordship,
the
page
next
61,
that they were
petition number 5.
engaged as master
15.
role workers initially by the national handler in the year, and their services were utilized in connection with the construction trial. Subsequently, they rendered under remand, represented before the authorities from the, as no decision was taken, they approached this court and they were disposed of them to consider they are complaining that in spite of such reasons, the cases were not considered and filed the reversal. On then having started the submission and having the effort. Then,
Then this takes note of that. May I come to the second paragraph? Lord?
why this? My goodness. Even the case, you want number 10, Prasanto Kumar Paul to be engaged, absorbed at 66 years.
So far as those who have crossed 60, we are not for that. All this got for the response from them to what happened thereafter if they had a recruitment drive.
File an RTI. This is nothing to do. RTI, they have an RTI. My goodness. How much cost on the lawyer? Half. 50% on the lawyer. Don't come up with all these things. Who will file an RTI? Mr. S. Bonik, the learning council submits that the petitioner would not like to further press the instant petition. The submits that the anxiety under which the instant petition has been filed by the petitioners is to know as to what transpired in the representation so submitted. which the petitioners are yet to know, and it is under such circumstances the writ petition has been filed. Ustud. It has been submitted by Mr. R. K. Talukdar that the respondent authorities duly has public information officer and the petitioner, if so, if so advised, can very well seek due information in that regard. So taking into account the above, the petitioner submits that he would not like to press the council submits that he would not like to press the instant writ petition. Accordingly, the writ petition stands dismissed with cost upon the council, 7,000. Upon the council, necessarily filing these things, paper degradation, environmental degradation. Cost none.
Obligement.
Last look at prima facie he was formed by the honorable court regarding the maintainability issue.
Oh, yes.
In terms of the judgment passed by coordinate bench lordship.
Hmm.
It was held by the coordinate bench that said notification dated 15/11/2014 cannot be read as if all persons suffering from any accident except hit and run case where the offending vehicle remained unidentified in the final form after police investigation would become entitled to ex gratia where other statutory remedies are available. So, lordship, I have supplied the copies of a division bench order, lordship. Wherein
This is under 357A. These have nothing to do with this.
but it was held by your lordship that schedule to the Motor Vehicle Act can also be taken into account.
It's okay. But this judgment which has been passed by the coordinate bench out here categorically deals with that judgment of this court as well as also the Supreme Court.
And apart from that, lordship, the judgment passed by coordinate bench has also been appealed, lordship.
Let it be. Very well. As of now, we stand in the same footing.
In my humble submission, the matter may be referred, lordship.
Only thing is your petition requires to be dismissed. You cannot get us so much a year. You have already have the vehicle. Why you are not getting the amount from them? What has happened to the criminal case?
Already, lordship, it's closed already.
Well,
2016 perhaps.
Why?
You know, on the basis of benefit of doubt, it was acquitted.
Hello?
My humble submission, the order of the division bench can be considered, lordship.
I will take note of in the order. Heard Mr. G.R.A. Motakui, the learned counsel appearing on behalf of the petitioner. Mr. A. Bhattacharjee appears on behalf of the Revenue Department and Mr. S. Borua appears on behalf of the Government of Assam. This court, by an order dated 26/7/2024, was of the opinion that the instant writ petition is covered by the judgment of the coordinate bench dated 21/6/2024 in the case of Monisa Khatun versus State of Assam, bracket writ petition number 2700/2023. However, the learned counsel appearing on behalf of the petitioner submitted that there are division bench judgments which permits such compensation and accordingly have placed an order passed in by the division bench in the case of PIL number 26/2023, 2013. This court have duly perused the said order passed in the said public interest litigation. And the said order relates to compensation in terms with section 357A of the CRPC.
I interfere, Lordship.
It has also been mentioned by the division bench in the said judgment that the that all pending cases of individual victims be taken into account, be considered in terms with the objects and the provisions of the scheme made in terms with section 357A of the CRPC. This court have also taken note of the judgment passed by the coordinate bench wherein reference was drawn to the judgments of the Supreme Court in the case of Reliance General Insurance Co. Limited versus Shashi Sharma, reported in 2016 9 SEC 627, as well as the National Insurance Co. Limited versus Birendra and others, reported in 2020 11 SEC 356. Well, upon referring to the said judgments, the learned coordinate bench of this court categorically opined at paragraph 16 and 17 that the notification dated 15/11/2014 cannot be read as if all persons suffering from any accident except hit and run case where the offending vehicle remains unidentified in the final form after police investigation would be entitled to ex gratia where other statutory remedy is available. The claims so made in the instant writ petition refers to a notification which was issued of the year 2000, notification dated 24/4/2007, which is parameteria to the notification which was issued on 15/11/2014, insofar as the compensation is concerned. However, the compensation amount is different. And insofar as the basis on which the compensation is being paid. However, the quantum of the compensation is different. Under such circumstances, in the opinion of this court, if the observations so made by the coordinate bench in its order date in the case of Monisa Khatun Supra being binding on this court, and that too when the same have been duly applied on the basis of a judgment passed by the Supreme Court referred to here in above, this court finds no reason to entertain the instant writ petition. Accordingly, the instant writ petition stands dismissed. Be that as it may, the petitioners herein would be entitled, be that here, as it may, the adjudication herein shall not deprive the petitioner of the dues otherwise of the and of its entitlement, if otherwise payable under the Motor Vehicles Act 1988.
59.
Yes, what is this?
Your lordship. Well, maybe petitioner is challenging here the order passed by the Principal Secretary NC Hills Autonomous Council at page 40. My lord, the different departments are allotted different grants, my lord, from time to time. Now, what has happened after these grants have been released to them, and then, my lord, also administrative.
Which order you are challenging?
Page 40, my lord.
40. Pursuant to the dues to undertake development works under department and the fund allocated to them. The same would be implemented by the other departments. Yes, Nan?
Now, my lord, your lordship will kindly see the at page 21, my lord, Annexure F series. These are the orders whereby, my lord, already administrative approvals were granted, my lord, against this particular grants, my lord. 15 Finance Commission, both tied and untied grants. I will just read out one numbers. So and so, NC Hills Autonomous Council is pleased to accord administrative approval for an amount of rupees so and so. Now, against the particular amount, my lord, the works are, my lord, laid out.
Have the works been allotted to you?
Yes, these are administrative approval is granted, and they have marked which fund is to be, my lord, spent for which works, my lord. And
Where is the work granted to you?
the work is here, my lord.
Where?
The listed, the name of the scheme is given, my lord.
No, which work? Where is your work order?
Work order, no, my lord. This grant is for the particular department, which is Panchayat and Rural Development, PNRD department.
By?
Both by the government, my lord, under 15 Finance Commission for the year 2023-24. There are two installments, my lord. First installment and second installment. My lord.
Now, how are you involved?
My lord, I am involved in the sense, my lord, I had given my commitments. I had, my lord, they have also approved the granted administrative approval to these schemes, my lord, under my department. These schemes, my lord.
Under
from
yours?
Annexure F series, my lord. And,
Who are you?
My lord, I am the member, my lord, heading this department.
He's not a contractor, my lord. He's an elected.
I am elected member, my lord.
He's also the in charge of the department. He is an executive member, lordship.
There are two.
EM.
There are two.
He is the EM of this department. He is being aggrieved in the fund has
Social
been
welfare
diverted.
and PNRD.
Oh, he's aggrieved by his own people.
Yes,
On who?
Fund has been diverted from his
At the
department to
last
other
moment,
department.
My goodness. Why you are not fighting it out amongst yourself in the assembly? You have a small assembly with you. What are you challenging?
Out of them.
Where is the representation? Nothing has come out. Or you were just verbally fighting. And so file representation. No.
Your lordship will kindly see, my lord, no reason, nothing is assigned, my lord, all of a sudden.
What reasons? These are all administrative. They have own duty out there.
My lord, my lord. They,
Pursuant to the DO's letter of Honorable CM NHIC, Haflong,
Not Kachai, but
to undertake development works under the department fisheries so and so, the fund allotted to the PNRD department under the fisheries so and so for the year is hereby put on hold. The same would be implemented by the other line department. So your fund to the PNRD, you are PNRD, so you don't have money.
social welfare and PNRD.
So it is amongst yourself. And you don't belong to the same party.
We belong to the same party, my lord.
Then it is something Something like a minister filing today a writ petition against the chief minister's direction.
This is something else.
Something like that. A minister filing a writ petition against the decision of the chief minister.
And that will be, my lord, the, at the,
And belonging to the same party.
belonging to the same party, that is all right.
So
But
this
this
court
is a
now,
commitment,
this court, now, Mr. Goswami, you want this court to intervene between the fight between you out there in the legislative assembly.
No, five people, my lord, this is not a, this shouldn't be my humble submission, this shouldn't be backed by any political reason.
Huh?
Just because, my lord, this action, my lord, that we have brought before your lordship, my lord. If this is backed by a political decision.
Why you are not making the deputy, the CM a party?
Yeah, principal
the
secretary,
CM
is a-
of the party.
principal secretary is a party.
No, make the CM at the party because he is doing, you are also exercising as a minister. Make the chief executive member also a party. Otherwise, you have no business. Making.
Huh? Approval is given.
Mr. B.D. Goswami submits that he would like to file an, well, how do you do it now? If you want to make the CM a party, you have to make allegation against him and they amend the request.
My lord, allegation will come from here only. Your lordship will kindly see pursuant to the DO letter of honor, which we have no copy, my lord, of course, but then he has passed this order at the behest of the honorable CM or whatever he says.
The CM has done this. He's only passing the order. So if nothing happened out there in the cabinet. So you are now assailing it under 226. You have a cabinet.
Yeah, but we can make him a party now.
Make him a
On the
party.
basis of this.
B.D. Goswami submits the council submits that he would like to file an application for including the chief executive member of the Dimahasa Autonomous Council as a
This
party.
is not Kachar Hills Autonomous.
Huh? Not Kachar.
Their name is not Kachar Hills.
No, Dimahasa. Dimahasa Autonomous Council as a party to the instant proceedings. Time 2 weeks. How much time? How much? 1 week time is granted in that regard. Is the matter again on 9th? 9th possible? 9th of August.
Not so.
Number 16 for admission, part third.
So lordship can see the last order 29/4/2024.
Then what happened?
King, my lord.
Oh,
Department of Home has
in the meantime, the said amount to
Yeah, it
which
is, my
the
lord.
petitioner is entitled to along with, who are you?
My lord, our name was reflected in the cost list, WPT and BC. And my senior is just on the way,
Who is your senior?
Ardhar.
Fantastic. Here all along, Mr. B.J. Talukder is appearing. Where is he? Why this order has not yet been complied with? Affidavit filed. Hello, we asked the additional district commissioner Kamrup to be present in court. The learned counsel appearing on behalf of the petitioner submits that the order passed by this court on 29/4/2024 have not yet been complied with. Full stop. It is also seen that none has appeared on behalf of the petitioner, on behalf of the respondents, and more particularly, the additional district commissioner, Kamrup, who have been specifically directed to make the payment So accordingly, this court fixes the matter again on 19th of August 2024, on 12th of August 2024, on which date the additional deputy commissioner, Kamrup, shall be present in the court at 10:30 a.m. through video conferencing link to be provided by the state council.
Also, on previous order, they have been directed to amend the title.
What amend the constitution? There was a direction to make payment. When you don't know, don't make it. We'll have the additional district commissioner.
No, also, prior to that, let me have
Nothing
my
doing.
discussion because I'm.
Nothing doing. No payment has been made, none has appeared.
If at all the payment is made, then the dispense with.
Nothing will hear, none has appeared. Don't come up with it. You are sitting out there.
No, Lordship, I was very much there. I was there.
Then, why didn't none has appeared? There was somebody else who was appearing.
No,
Nothing.
she was appearing for the WPTBC.
My lord,
We are not concerned. I don't know who there was a direction to make payment to the additional district commissioner. Why it has not yet been paid? At over.
my lord, I just want to inform that this department doesn't exist. WPTBC and I'm not appearing for them anymore.
That's why.
We directed the additional district commissioner to pay. Matter ends. I'm not concerned with all these WPD. And what is the matter? Your land has been taken. Okay, if the department does not remain, then you don't require that property. Return the property to the petitioner. Return the property to the petitioner.
My lord,
Whoever it is, we'll ask the chief secretary to do so.
my lord, here.
Nothing doing.
Social justice empowerment.
I am not concerned. If the department does not exist, how could you take his land?
My lord.
This is a case of his land being taken over by the home department.
Oh.
I don't understand. What are you? This is a case where his land was taken over. How does the WPT come in? This has nothing to do with this WPT business. No. Are you aware? This item is 3923/2017. This is a case where the petitioner's land has been taken by the police authorities for having a Hakim police station or wherever, whatever may be, and till date they have not paid the compensation. How does the WPT has any business out there?
My lord, I'm appearing for item 16 there.
Huh?
16, this is 60. 60.
My lord, I thought it was 16.
This is 16.
Confusing it with 16.
60 and 16.
Lordship, 16. There's an instruction I have received, Your Lordship. 16, this is 16, Your Lordship. 16.
Showing in the
16.
It's showing 16 in that board, my lord.
60.
616.
And what is this item?
60.
60. Oh.
That is where, my lord, we got the confusion.
Yes. What is your instruction? Have you paid the money? Now what has happened?
This is the instruction that I received, Your Lordship.
So, how is it relevant?
F2, Your Lordship.
Has the financial sanction been granted or not?
F2, Your Lordship.
Get your instruction. Nothing doing. All these things, this matter can't get delayed. Every time
Lordship, F2, Your Lordship.
we will ask this Amitabh Sinha to pay from his own pocket all the interest. The interest which this court has fixed at 9%, na? 15%. 15% it will be paid from the pocket of this officer, as well as also the Aminus Talukdar. This is public money. Your delaying is he is getting it. He has a statutory right to get it.
Lordship, F2, Your Lordship.
We are here to protect. The police is here to protect the life and property of a person. Here, the police takes over the property by force. Get your instruction. 2 o'clock.
12. 12.
None appears on behalf of the petitioner on call when the matter is taken. For the end of justice, the matter stands adjourned to be listed again on 12th of August 2024. It is made clear if the petitioner is not represented on the next date, it shall be presumed that the petitioner has lost interest in the matter and accordingly appropriate order will be passed.
May please, Your Lordship.
I heard Mr. P.P. Dutta, the learned counsel, appearing on behalf of the petitioner. D. Goswami appears on behalf of the respondent numbers 1, 2, 3, 1, 2, and 3. The instant writ petition has been filed challenging the notice of demand issued by reference number PF/DIB/recovery/2024-DE-256/817-19 dated 26/2024, as well as for other consequential reliefs as regards the said notice. Mrs. G. Goswami submits on instructions that the said notice which was issued to the petitioner referred to herein above have been withdrawn upon reconciliation of the accounts.
It shall be withdrawn. Shall be withdrawn.
Shall be withdrawn in view of the reconciliation of the accounts. Mrs. Goswami further submits that the respondent authorities would not insist upon the said notice in view of the communication which have been addressed to her. The said communication, copy of the said communication was placed before this court, which is kept on record and marked with the letter X. So taking into account the said communication, which has marked with the letter X, as well as the submission made by Mrs. G. Goswami, the learned counsel, appearing on behalf of the respondent numbers 1 to 3. The notice the impugned notice is deemed to have been withdrawn. And accordingly, the respondent authority shall not insist on the said notice. First, it is however made clear that the respondent authorities would be it is however made clear that the instant order so passed shall not preclude the respondent authorities to take appropriate action by issuing due notice. The above the instant petitions are disposed. Yes.
Telephonic instruction from the authority, you told that this will be disbursed or possibly within 2 weeks.
2 days.
2 weeks.
So again, who is going to pay the interest? Interest is accumulating.
Let us have step by step money.
Those persons will be paying.
Because it is lying with the finance department for sanction of that amount.
It can't be delayed. Can't keep on delaying. There was a specific direction 2 months,
Before 15th August.
3 months before. Huh?
After 2 weeks.
Make the payment by 12th August. We are having this matter on 12th. Get the matter really disbursed. Mr. B.J. Talukdar, Learned Counsel, appearing on behalf of the respondent, submits the amount to which the petitioner is entitled to in view of the order passed by this court on 29/4/2024 would be disbursed to the petitioner within
My submission is within 2 weeks, my lord.
on or before 14th of August 2024. Taking into account the above, list the matter again on 16th of August 2024 for an update.
Fine. Fix it to.
May I please? Petitioner before lordship, my lord. Over.
Where's Mr. K. Gogoi?
Yes.
What do you have to say?
See, we have stated our stand in paragraph 6, 7, 8, 10, 12, and 13. We have stated our stand, Lordship, in paragraph 6, 7, 8, 10, 12, and 13 of the reply, Lordship, affidavit in opposition, Lordship.
6, 7, 8.
Lordship. My lord, may kindly peruse paragraph 8, Lordship. Then Lordship, 12 and 13, Lordship. Lordship, may kindly peruse 13. Internal page 93, Lordship, running page 93, Lordship. Then also annex are page 116, my lord, may kindly peruse 116. paragraph 2 lordship.
Does the municipal bylaws require the permission to be taken from you?
That is not there, lordship. That is not there. That part is not there, lordship. Otherwise, lordship, it's only a request him to lordship, not a direction, lordship. Lordship, my lord may kindly pair page 36 and 38, lordship. Then lordship may kindly come to page 37, lordship. Page 37, lordship.
In 2021, which was the notification, which was letter, which was in holding the area?
2015 as well as lordship, that 2015 is there, lordship. There was a letter from the GMC lordship, but no, not in the lordship, the bylaws, it is not there, lordship. এখন আসছে এখন GMC letter দিয়েছে। না না bylaw থেকে বলছি না। দেখো ডাক্তার দেখো।
And what is the power to exercise these guidelines?
Yes, as per the lordship. It's as per the lordship, MOD lordship, they have entrusted the power, lordship. MOD delegated the power, lordship, regarding restricted zone on the basis of Ministry of Defence, lordship. On the basis of that, they have issued, lordship.
Ministry of Defence power emanates from where?
My MOD lordship, there the instruction is there, instruction and notification.
Instruction. Instruction comes from where? Where's the law? You need a law because here you are interfering with a right under 300A.
Lordship.
Then where is the
That
law?
is there. Otherwise, on the basis of the MOD's notifications, which are issued time to time regarding lordship.
But would these instructions be law?
That part I cannot think. Otherwise,
Then
otherwise.
How do you interfere with
Otherwise,
300A?
it is a restricted zone, lordship. That's why it was given, lordship. One letter was there from the GMC, lord. It is also not visible to. The GMC letter also, they have indicated it's 2000 meter, although it is not visible that, but that's why I'm not bringing it in the record, lordship.
Is it to whom?
It was issued by the lordship municipal department. They have indicated that within the radius of 2000 meters, 2 kilometers, lordship. 2 kilometers. Within the radius of 2 kilometers.
If a permission is to be taken with a radius of 2 kilometers, tell me one thing. What right do you have out there? Then acquire all the land within the radius of 2 kilometers. And don't do anything.
It is not our notification. It is of the GMC's notification.
GMC will do anything.
GMC's notification, not our notification also. We have just indicated earlier it was 1 kilometer, then 500, now 100 meters, lordship. It's a NOC, lordship, not a other thing. Just they have to.
NOC is the biggest problem.
Otherwise, they are getting the NOC from the GMC.
Yeah. Under what provision you are doing?
On the basis of the MOD's instruction, that.
Mr. A.K. Bhuyan, the Learned Counsel appearing on behalf of the petitioner.
My lord, I have filed my EMP have filed its affidavit, but it has not come on record because of some technical defect, my lord. I can hand over the affidavit.
What is your stand?
So there's a It is bylaws the Guwahati Building Construction Regulation bylaws of 2022, my lord. Where in clause 117, it says that a clearance from local authority may be obtained before issuing the building permission in the vicinity of army establishment as per latest circular of the defense or any other competent authority, my lord.
Do you take that permission?
But they have to take, petition has to take the permission. That is also said that 2000 meters.
It is their notification was, it is not our notification.
It has not come on record, my lord.
This came in 2022
This is the
and you gave the permission in 2021. Right? Heard Mr. A.K. Bhuiyan, the learned counsel, appearing on behalf of the petitioner. Mr. A. Bobo appears on behalf of the respondent numbers 1, 2, 3, 4. And Mr. S. Bora appears on behalf of the respondent number 5 and 6. The petitioner herein has approached the instant has filed the instant writ petition challenging the letter dated 23/1/2024 issued by the
It's 37 also.
he's not a party. Issued by the Lieutenant Colonel, Staff Officer at ADMN, bracket for the Group Commander. Issued by the Lieutenant Colonel, Staff Officer at ADMN, bracket for the respondent number 4, thereby directing the petitioner that as his land falls under the restricted zone, he was advised to obtain the no objection certificate from the local military authority through Commissioner, Guwahati Municipal Corporation, bracket GMC State Fed Building, Bhangagarh, and after obtaining the no objection certificate to intimate the issuing authority, to intimate the officer who had issued the said communication before start of fresh construction. It was also mentioned in the said notice that in absence of a no objection certificate taken from the local military authority, the office of the respondent number 4 shall initiate FIR as per the government procedure. The case of the petitioner herein is that the petitioner is the owner of a plot of land measuring 2 kathas under dark number 281, covered by patta number 136 under Jalukbari Moja. The petitioner accordingly obtained the permission from the Guwahati Municipal Corporation as well as the Guwahati Metropolitan Development Authority on 8/7/2021 for construction of a residential ground plus 2 floor storied building over the said plot of land. After obtaining the permission, the petitioner started construction of the building in a phased manner. The petitioner initially constructed only the roof of the ground floor plus 2 floors which were completed as far back as in 2021-22 itself. However, on account of personal and financial reasons, the petitioner could not carry out the further construction of the walls of the building. Subsequently, in the year 2024, when the petitioner started construction.
If I can take leave, my lord, I have another case that may come up, my lord, in the meantime. If I can take leave, my lord.
Oh, please. 2024, when the petitioner started again reconstruction of the building, the petitioner received the impugned notice dated 23/1/2024, issued by the Lieutenant Colonel, Staff Officer, Administration, ADMN, for the respondent number 4, thereby directing the petitioner to obtain a no objection certificate from the Guwahati Municipal Corporation and to intimate the said officer. It is under such circumstances the petitioner has approached this court by filing the instant writ petition. It is the case of the pursuant to the filing of
No objection from the local military authorities.
no objection from the local
Military authorities.
military authority. It is the case of the petitioner that the petitioner's building is situated beyond 50 meters from the local military authority, brackets station cell headquarter 51 sub area Narengi cantonment, and as such the petitioner could not have been directed by the impugned notice. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the guidelines issued by the Ministry of Defence, Government of India, dated 21st of October 2016, wherein it has been mentioned that in respect to security, in respect to defense establishments / installations located at 193 stations as listed in Part A of the annexure to the said circular, security restrictions shall apply up to 10 meters from the outer wall of such defense establishment / installation to maintain a clear line of sight for effective surveillance. It was also mentioned in the said circular that any construction on the repair activity within such restricted zone of 10 meters would require a prior no objection certificate from the local military authority / the defense establishment. The learned counsel for the petitioner drew the attention of this court to the Part A of the annexure, and more particularly to serial number 43, wherein the area wherein the petitioner has his land and constructions are being carried out have been duly mentioned. The learned counsel therefore submits that in terms with the circular dated 21/10/2016, the requirement of obtaining the no objection certificate from the local military authority would only arise if the construction is carried out within 10 meters from the installation in question. The learned counsel for the petitioner further drew the attention of this court to another set of guidelines issued on 23rd of December 2022, wherein it has been mentioned that that any construction coming within 50 meters radius of this defense establishment, which is listed at Annexure A, being a security hazard, the matter should be referred to immediately to the next higher authority in the chain of command. So in such circumstances, the next higher authority is having been convinced that then the station commander may convey its objection or views to the local municipality or the state government agencies. In case the municipal authority or the state government do not take cognizance of such said objection, then the matter may be taken up with the higher authorities if need be through the AHQ/MOD. Full stop. The Learned Counsel, appearing on behalf of the petitioner, further drew attention to Annexure A and more particularly to serial number 26, wherein the land of the petitioner is situated wherein the constructions are being carried out. He therefore submits that even as per the circular dated guidelines dated 23/12/2022, also the respondent as the land of the petitioner is situated beyond 50 meters, the question of the said circular guidelines being applicable does not arise. Full stop. It is seen that pursuant to the filing of the instant petition, this court, by an order dated 12/2/2024, issued notice and directed that till the returnable date, the status quo as regards the building of the petitioner shall be maintained, and there shall not be any coercive action by the respondent number 1 to 4 on the basis of the impugned notice dated 23/1/2024. Mr. K. Gogoi, pursuant to the notice, the respondents numbers 1 to 4 had filed an affidavit in opposition. In the said affidavit in opposition, it had been stated that the group headquarters have been endorsed with the responsibility for watch and ward duties for the defense area locations in Khantipur and Bhutnath by its station HQ cell SOP number 6555/R/Q3/land dated 11/11/2011. Accordingly, the group GO HQ approached the petitioner to obtain the NOC from the local military authority in terms of the guidelines for issuance of the NOC for building construction promulgated by the Ministry of Defense dated 18/5/2011, which states that where the local municipal laws do not require consultation with the station commander, yet the station commander feels that any construction coming within 100 meters radius of a defense establishment can be a security hazard, he should refer the matter immediately to his higher authority in the chain of command. In case of the next higher authority is also not convinced, then the station commander may convey his objection or views to the local municipal authority or the state government agencies. It was also mentioned that at no point of time the petitioner was threatened and only informed about the procedure that will be adopted if the NOC was not obtained prior to commencing the construction. It is also seen that the station cell HQ 51 sub-area it is also seen from the said affidavit that the Guwahati Development Department, Government of Assam, had issued a letter on 7th of June 2010, whereby instructions were issued to the Guwahati Municipal Corporation to obtain NOC from the local military authority before issuing building permission within 2,000 meters from the boundary of the cantonment, and have also requested Guwahati Municipal Corporation to incorporate these provisions in the building bylaws of the Guwahati. In addition to that, it has also been mentioned that the NOC guidelines promulgated by the Government of India, Ministry of Defense, by letter dated 23/12/2022 have been kept in abeyance by the Ministry of Defense, Government of India, by the another communication dated 23/2/2023. And the NOC guidelines have been reverted back to the status as on 22/12/2022, that is NOC guidelines of 18th of May 2011. Bracket with amendment dated 18/3/2015 and 17/11/2015. And what about the 21/10/2016?
21/10/2016, it is not reflected here. Otherwise, Lordship, now it is Lordship may kindly pay us that is there. Page 119, Lordship. And that notice was on the basis of that, Lordship. Page 119, Lordship.
Where issued this?
No, Lordship, it is page 117, Lordship. That was done on the basis of 21st March 2023. 117.
Well, it is also seen that on 21st of March 2023, another set of guidelines have been issued, which refers to, wherein clause 3B seems to be in parameteria 2, the guidelines which were issued in respect to guidelines issued in dated 18/5/2011. Isn't it?
Yes. Lordship, in the 3B Lordship, it says that Lordship, 500 meters.
Huh?
3B Lordship.
That is for 4-story.
Lordship.
No, it is the same.
Lordship,
Kindly
same,
come to
same,
page
same,
53.
Same, Lordship, same.
B is parameteria with 3B.
Yes, same Lordship, same.
The petitioner have also filed an affidavit in opposition to the affidavit filed by the respondent, numbers 1 to 4, reiterating the stand which have been taken in the writ petition. The respondent number 5 and 6 have not filed any affidavit in opposition. However, it has been submitted by Mr. Esbora that on account of certain technicalities, the said affidavit so filed by the respondent number 5 has not been accepted by the registry. Be that as it may, a copy of the said affidavit have been the copy of the said affidavit, which was to be filed on behalf of the respondent number 5 and 6, was placed before this court. It is seen that the stand which have been taken by the respondent authorities it is seen from the affidavit which have been filed by the respondent number 5 and 6 that there is no denial to the fact that the petitioner was duly issued the no objection certificate by the authorities concerned on 18/7/2021. However, there is a mention in the affidavit as regards the Assam Unified Building Construction Record Regulation Bylaws 2022. Be that as it may, the said bylaws are of the year 2000, which had come into force in the year 2022, whereas the NOC was issued as far back as on 18/7/2021. And as such, the said regulation bylaws of 2022 has no relevance to the instant matter. In the backdrop of the above, this court have also heard the learned counsels appearing on behalf of the parties and have also given the anxious consideration to the above matter to the respective submissions. Full stop. From the materials on record, from the contents of the writ petition as well as the enclosures therein, it is seen that the petitioner herein was issued a no objection certificate by the respondent number 5 and 6 on 18/7/2021. This court have also perused the various guidelines which have been enclosed to the writ petition and as Annexure Roman 7 and Roman 8. Annexure Roman 7, Annexure Roman 5, Roman 6, Roman 6, Roman 7, and Roman 8. From a perusal of Annexure Roman 5, it is seen that in Annexure Roman 5, which is the guideline dated 18/5/2011, there is a stipulation contained in clause B so far as the same would be applicable to the instant case. The said clause B, it being relevant, is reproduced here in under. In terms of page 53 top. From a perusal of the said clause, quoted clause above, it would be seen that it is only when the station commander feels that any construction coming within 100 meters for multi-story building of more than 4 story, the distance shall be 500 meters, comma, radius, meters bracket, radius of defense establishment can be a security hazard. There's a requirement for the station commander to refer the matter immediately to the next higher authority in the chain of command. And it is when there is a subjective satisfaction of the next higher authority that it is a security hazard, then the station commander shall convey its objection or views to the local municipality or the state government agencies. And it is only when the municipal authority or the state government do not take cognizance of the said objection, then the matter would be taken up by the higher authority, if need be, through the AHQ/MOD. Full stop. This particular clause finds reference again to the latest circular which have been issued on 21, latest guidelines which were issued on 21/3/2023 and have been mentioned in clause 3B. A perusal of this clause quoted above, which is parameter with clause B of the guidelines dated 21/3/2023, would show that the respondent number 4 on its own cannot take any steps. It can only take steps provided it arrives at the subjective satisfaction that the construction of the building made within 100 meters or for multi-storied building more than 4 storied, 500 meters is a security hazard. Upon arriving at that opinion, the said aspect has to be referred to the next higher authority, who has also to arrive at a subjective satisfaction. The said authority, the higher authority also on its own cannot take any steps. The higher authority can at best put its objections or views to the local municipality or the state government agency. And in the circumstance, the municipality or the state government agencies do not take cognizance of the said objection, then it has to be taken up through the higher authorities, if need be, through the AHQ/MOD. The reliance placed by the respondents out here, respondents by way of the affidavit, to the guidelines dated 18/5/2011 as well as the 21/3/2023, on the basis of which the impugned community notice was issued. In the opinion of this court, is totally misplaced in as much as the officer who had issued the communication on behalf of the respondent number 4 could not have issued that said communication if at all the guidelines are to be followed. This court also finds it very relevant to take note of the guidelines dated 21/3/2023. that it further mandates that if the construction is not seen as a security threat by the station commander, there is a mandate that the station commander is neither required to raise an objection nor issue an NOC. And what is this? And the individual should be allowed to construct on his property without any interference. Nothing has been placed on record that the station commander, that is the respondent number 4, had arrived at any subjective satisfaction to the effect that the construction so carried out by the petitioner is a security threat. Therefore, in terms with clause 4D of the guidelines dated 21/3/2023, also the impugned notice stated where impugned notice is where page 36
23rd January 24.
23/1/2024 is bad in law and accordingly stands set aside, is bad in law. Also, in addition to that, a very perusal of the impugned notice would show that there is not even a single whisper that the construction so carried out is a security threat. It seems that the impugned notice have been issued without proper application of mind, even to the extent circulars of the guidelines. Consequently, the impugned circular dated 23/1/2024 being unsustainable, being not cannot be sustained in law, or even as per the guidelines of the respondent numbers 1 to 4, for which they stay sets aside and quashed.
Instead of circular lawsuit, instead of circular lawsuit, indicate notice or letter lawsuit. That 21.
Impugned notice, I'm saying. Impugned notice, I'm saying. No, I'm saying does not conform to the
Circular dated so.
circular oblique guidelines. Extend circular oblique. Interim orders so passed earlier stands vacant.
Item number 30, information.
Yes, what is this?
Your Lordship, this petition was filed for winding up of the company. This petition was filed for the winding up of the respondent company, my lord, in 2004, my lord, under Companies Act of 1956, my lord. Thereafter, the respondent had appeared before the Honorable Court, and my lord, they have filed an affidavit in opposition stating that the said company made a reference before the Sikh Industrial and Financial Reconstitution Board, my lord. Under the-
22.
Yes, my lord. Section 15 and 22, my lord. The Sikh Industrial Company Special Provision Act of 1958, my lord. in pursuant to that, my lord, this matter was stayed, my lord. And once the matter was stayed, my lord, status report was called from the petitioner side also and from the respondent company also, my lord. We filed an affidavit before the Honorable High Court stating that we have no information regarding that proceedings, my lord. Respondent had filed the affidavit or no, my lord, I could not have checked properly that part, my lord. Since then, my lord, 2007, the matter has come today before your lordships. Now, my lord, there are two practical difficulty which has arose, my lord. Now, this act, the Sikh Industrial Companies Special Provision Act was repealed, my lord. This was repealed in the 1st December of 2016, my lord.
IBC.
It was sent to the IBC, my lord, under NCLT, my lord. And what had happened, my lord, this company, respondent company still survives, my lord. I have checked the status, my lord, this company survives, my lord. So, my case is also under 1956 Act, my lord. And that has been substituted by Companies Act of 2013, my lord. So under such circumstances, my lord, I have to take instruction from my client stating that this necessary changes has to be made before your lordship, or your lordship may decide this matter.
This power has not been transferred, na, to the NCLT.
My lord, the notification which relates, my lord, does not say that this part has not been transferred.
No, this power has not been transferred.
Yes, my lord, this has not been transferred.
Therefore, all the company petitions are here.
Yes, my lord.
Okay. Now, who was appearing on behalf of the respondent?
Part of the respondent, my lord. Mr. Advocate M. Kartik.
Kotogi. So as of now, the reference has gone.
Reference has gone, my lord. And
Sika.
Yes, Sika has gone. Whether the same proceeding is going on before the NCLT or not, my lord, that is not clear, my lord.
The order.
Yes, my lord. This Honorable High Court stayed the matter by order dated 6/6/2006, my lord.
6/6?
6/6/2006, my lord.
6/2006. Has also to be stayed till conclusion of AR. It is ordered accordingly. 8/6, it was stayed. Then the matter came up, shall file an affidavit indicating the present position of the proceedings before the BIFR. Then what happened? The information coming before the court is not being clear with regard to the present stage of proceedings before the BIFR. The responding is directed to lay their forces information. Well, none appears for either of the parties in the case. Case record stands adjourned by 4 weeks. Where is the company? How much amount for which you have filed?
The initial amount was, my lord, 75,000 first, my lord, and it was 2,44,033 rupees, my lord.
Huh?
2,44,033 rupees, my lord.
75,000 only.
The 75,000 was the original amount, my lord.
Hmm.
And the amount which on the date of filing was 2,44,033, my lord.
Hmm.
Now, as per the 1956 Act says that if it is above 1 lakh, the matter can be filed for winding up of the company. It was under 1956 Act.
Would the debt include the interest?
Debt includes the interest as of that date. As of date, the filing of the petition, my lord. If it is above 1 lakh, my lord, that can be entertained, my lord.
How do you say so?
Because, my lord, while calculating the interest part, if that is not paid, comes.
Unless the agreement categorically says that you are entitled to that interest.
There was a hire purchase agreement, my lord. There was a finance which was made to the respondent company, my lord.
Understood. But unless the agreement says that you are entitled to this amount, can that be said to be a valid debt?
That is a valid question, my lord. But I have to just go through that part, my lord. Lord, the
Where is the office?
office,
Registered office?
Kolkata, my lord, Kolkata, my lord.
Then how did you file this here?
Lord, as, my lord, the defect, my lord. My lord, actually, the finance was made for this.
So what?
This state. This year,
No,
my lord.
you cannot file it anywhere. I think the company petition has to be filed only before the court wherein the registered office of the company is there. Isn't that, madam? Then
What is this, the present
you need to
status of the-
prepare more. Yeah. Yes. And the person who is prepared is there. Let me dismiss it in his hands only.
After 20 years.
So what?
In the meantime, our file is also misplaced.
How did you file it here?
No, at
You-
that time.
No, at that time also the law was same.
Now,
It
I
had to
think
be
that
filed
this-
before the
this
registered
restaurant
office.
company was within the state of Assam.
Huh?
Because that's a registered company, perhaps at.
Perhaps? What is this perhaps business?
Otherwise, that could not have been entertained.
And the company having its registered office at Makum Road.
In Sukia, perhaps. That was the registered office.
Referendum as so and so. Very well, so and- Where is it to show that it has its office?
Post title.
Huh?
In the post title.
Because all your letters are issued to Calcutta.
But a registered office was at Makum Road, Sukia.
Huh? Everything is in Calcutta and you have come here.
Office was at Makum Road.
No. Mesa Jaya under hire purchase agreement, Makum Road.
Correspondence may be there at Calcutta. office.
Correspondence what?
Yeah, head office may be there, Calcutta. Definitely.
Anyways, try to make effect service upon them. Heard Mr. R.C. Sansuti, the learned counsel appearing on behalf of the petitioner. It is seen that the instant company petition have come up before this court after a hiatus of more than 15 years. The respondent is not represented. It is also seen that on account of certain proceedings initiated before the Board of Infrastructural BI and Financial Reconstruction under the Sikh Industrial Companies Act. The instant proceedings were stayed. It is, however, relevant to take note of that the said act, that is the Sikh Industrial Companies Act, have been repealed by the Insolvency and Bankruptcy Code 2016. Taking into account the above, this court directs the petitioner to effect service upon the respondent by way of registered post with AD. In addition to that, the petitioner also shall let the matter be listed again on 23rd of September, 11th of September 2024. August 2024. It is observed that if the petitioner is not, applicant is not represented on the next date, it shall be presumed that the applicant have lost interest in the matter, and accordingly appropriate order would be passed.
Company has been restructured under the IBC. That was in 2018 itself. So the original company, nothing is left. The resolution order was passed in 2018, 7th of December.
IBC is over.
Everything is over.
Then what it means?
No, it means nothing. It's as per the approved plan. They move as per the approved plan. Money is paid
IBC conduct.
as per the approved plan. They move. The resolution professional takes over.
And appears on behalf of the petitioner on call. Mrs. M. Hazarika, the learned senior counsel, submitted
The resolution plan.
that in respect to the respondent company, proceedings were initiated before the insolvency, before the
National Company
National Law
Company
Board
Law
Tribunal. And National Company Law Board
Tribunal.
NCLT. And Law National Company Law Tribunal. Very under the Insolvency and Bankruptcy Code 2016. And the resolution plan have also been approved. He therefore submits that in terms with section 31
Yes.
of the Insolvency and Bankruptcy Code 2016, any creditors would be bound by the said resolution plan, taking into account the provisions of section 31 of the Insolvency and Bankruptcy Code 2016. This court is of the opinion that nothing further survives in the instant proceedings. Accordingly, the instant company petition stands closed.
Obliged.
Lord, in this case, we have already issued communication to the prisoner regarding intending our intention to withdraw the Wakalatnama. But they have no contact with us, my lord. We have issued communication.
They have not contacted with you means you are bound. Argue now. Ardor, who was APL earlier, standing submits that the said department has been reorganized in 3 departments. You filed the amended.
No, my lord, it has not been.
What?
It was inadvertently left out.
Yes. What is the matter about?
Regarding inclusion of certain villages in the Thengal Kesari Autonomous Council, those places were not notified in the notification, my lord. That is the case.
Yes, now you.
My lord, my prime problem is that when I cannot argue this matter because this department doesn't exist. Well, the WPTBC, my lord.
No, we have already taken care of. You have earlier appeared. You must have forgotten that.
No.
You made that submission.
Yes, ma'am.
That this WPCTD department has been trifurcated into 3 departments.
My lord.
And accordingly, this court had made the government of Assam, principal secretary to the government of Assam Tribal Affairs Plains Department as a party. Now, but you appear for that department also.
Exactly, my lord.
Now come up with your submission.
Now, my lord. Thereafter, my lord, a copy has to be given to me so that I can communicate notices to be issued, my lord. I have to seek.
You have the earlier copy, give it to the.
No, my lord, I am, my lord's second file, my lord. That is the thing, my lord. I don't get a copy. I cannot get any instructions from the department, my lord. That is the thing, my lord. And these are very complex matter. Without instruction, my lord, it's become very difficult, my lord.
Has this been received?
Today we have sent it, my lord. We raised that post today.
You sent it today.
Yes, my lord.
And you mean to say that you have withdrawn?
Yes,
Absolutely. My goodness. While you cannot get away from this matter once you have taken it, till the other side has known that you want to withdraw. File your amended cost title and give a copy. Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner submits that on account of an inadvertent error, the fresh memo of parties have not been filed as directed by the order dated 11/10/2023. Full stop. He submits that within 2 days he would submit the said fresh memo of parties. Mr. Ardhar, who represents the newly impleaded respondent number 7, submits that he would require a copy of the writ petition. Mr. D. Chakraborty shall serve a copy of the writ petition during the course of the day. List the matter again on 2nd of September 2024. The respondent number 7 is directed to file their affidavit.
18.
That the petitioner before your lordship was assessed under the provisions of the VAT Act, my lord. And some assessment orders were passed for recovery. Preferred revisions, my lord. The revisions, my lord, although in appeal pre-deposit is required, revisions, my lord, by way of notifications, those pre-deposits were made mandatory. He made the pre-deposits. The better on the revision petitions were allowed, my lord. Now, this cases before your lordship because the money which he has deposited as pre-deposit, my lord, has not been refunded to him. When he raised it,
Lordship, here against the revisional order, the department had preferred appeal before the Assam Board of Revenue. And Lordship, thereon, since the amount involved was more than 50,000, it is about 40 crores. Lordship, due to lack of quorum in the Board of Revenue, the matter has not been taken up till date.
You have preferred an appeal?
Yes, yes, Lordship. I can give the numbers, Lordship, about 8 numbers we have preferred.
it's been a long time since, my lord, this appeal has been heard, but nothing has been done in the appeal. For want of quorum, of course, my lord.
But if it is a case of refund, you will be entitled to interest. They give, how much interest you give?
Lordship, that.
No, you give interest. As per the VAT Act, you have to give interest. How much? You give interest. Why do you worry? Now, as of now, into your petition, what you call, you are claiming interest at 9%. So under such circumstances, you will be entitled to interest. I think it is more than 9% you are entitled to. Because they otherwise charge 50%. You are entitled to 9% more than that. But if he has filed a
Yes,
Board of Revenue, where is the, what is the number?
Lordship, there are 8 numbers. Lordship, 2 STA of 22, 3 CST of 22. Lordship, I can give the numbers, Lordship.
Okay, file a short affidavit to that effect. Once that affidavit is being filed, we close this petition. And that will be subject because after all, that is a revenue.
Yes.
But there is no stay.
Lordship, due to lack, since the matter has to be taken up by the full bench of the Board of Revenue, due to lack of quorum, Lordship, the matter has not been taken up till date.
Who appoints the quorum?
Lordship, only the government after appointing members.
So that is the reason why the government is not appointing.
Lordship,
in order to save this.
I can't.
My goodness, what is wrong with the government?
Lordship, that I can't.
How can we now relegate some persons to the Board of Revenue if you don't have the quorum? You need 3 judges.
Yes.
One is the chairman. The other 2 are the members. There's no members.
Lordship, at this moment, as per my information, only 1 person is here. I think it's a member, Lordship.
No chairman also.
And this is happening from a long time, my lord.
And when did you file?
In 2021, December, Lordship.
issuing show cause also. My goodness. There's a limit to this. You're issuing a show cause to him.
Lordship, this I can't say. Lordship, it was because the appeal was filed before that. Lordship.
But if an appeal is filed, would it amount to stay? No? Because on the other hand, if it is the SSC other hand, would you stop? No. Then, if you don't get an order, move the writ petition against that order.
Lordship, that we are contemplating and it is under
Then-
preparation. Lordship.
This can't go on like this. You feel nothing as there's no stay order to that appeal, so you make the payment. Unless you obtain an order of stay to that order passed by the JCT.
Lordship may allow us sometime because we are preparing to file a writ petition against all the assessment years that is under appeal. Lordship may allow some, it will be filed, Lordship.
Now, heard Mr. G. Rahul, the learned counsel, appearing on behalf of the petitioner, and Mr. B. Chaudhary, the learned standing counsel, Finance and Taxation Department. The petitioner, being aggrieved by the various assessment orders passed for the assessment year 2005-6, 2006-7, 2007-8, and 2008-9, had prepared various revision applications before the Commissioner of Taxes, Assam. The said revision applications were later on endorsed to the Joint Commissioner of Taxes, Assam, for disposal. By various orders, the assessment orders which were passed against the petitioner in respect to the assessment for the years 2005-6, 2006-7, 2007-8, and 2008-9 were set aside and quashed. Under such circumstances, the petitioners who had deposited had to pre-deposit the amount at the time of filing of the revision applications have sought for refund of the said amount. The stand which have been taken by the respondents in the instant proceedings is that they are contemplating that the stand which have been taken that an appeals have been filed before the Learned Board of Revenue against the orders passed by the Joint Commissioner of Taxes, thereby allowing the revision applications filed by the petitioner. However, there is no stay order to the order so passed, or for that matter, there is no order to the effect that the refund should not be there is no order thereby saying that the petitioners herein would not be entitled to any refund, stating the petitioner's entitlement to the refund. Mr. B. Chaudhary, Learned Counsel for the Finance and Taxation Department, submits that the government of Assam will require some time to take effective steps in that regard. Accordingly, lists the matter again on 19th of August 2024 Pusto.
19.
Matter relates to demand of establishment charges in bonded warehouse. Lordship has already disposed of series of requisition, Malad. The similar matter. Here, we are supposed to deposit the amount of establishment charges by this order.
The instant writ petition has been filed challenging, heard Mr. N.K. Kolita, the learned counsel appearing on behalf of the writ petitioner. None appears on behalf of the excise department on call. The instant writ petition has been filed by the petitioner challenging the imposition of establishment charges, and the impugned notices dated 27/10/2021, 4/12/2021, and 27/1/2022. It has been brought to the attention of this court that this court had, by the judgment and order dated 9/5/2023 in WPC number 4575/2021, bracket of the MS Barak Warehouse Private Limited and another versus the state of Assam and two others, had held that the petitioners liable to pay the establishment charges in terms with clause 9 of the order dated 29/8/2016 till payment of the ad valorem excise duty as well as VAT on excise duty, a VAT on the basis of the orders passed by the authorities in terms with clause 3 of the office order dated 29/8/2016 are not paid, or such amount so demanded are not set aside in accordance with law. In addition to that, the respondent excise duty was also given the liberty to take such action as deemed fit for realizing the establishment cost. So, taking into account that the issue involved in the instant writ petition is similar, this court also dismisses the instant writ petition, thereby holding that the petitioners herein are liable to pay the establishment charges in terms with clause 9 of the order dated 29/8/2016 till payment of the ad valorem excise duty as well as the VAT on the basis of the orders passed by the authorities in terms with clause 3 of the office order dated 29/8/2016 are not paid, or such amounts so demanded are not set aside in accordance with law. In addition to that, the respondent authorities would also be at liberty to take appropriate action as per the provisions of law for realization of the establishment charges. With the above, the petition stands disputed.
Lord, this petition is regarding non-payment of remuneration to the petitioner for his services as inquiry officer of the departmental proceeding. The petitioner was engaged by the managing director of AFDC to conduct the departmental proceeding. Lordship, turn to page 14. It was issued by the then director S.K. Das to S.K. Nath. This is the petitioner, my lord. Then, my lord, similar.
S.K. Nath, IS, retired Mathura Nagar, Guwahati, regarding inquiry for conducting inquiry against Subhash so and so. How much is your amount?
Lordship, may turn to page 16. The terms and conditions were asked from the petitioner. Petitioner submitted, Lordship, an office assistant with so and so, and an amount of rupees 75,000 per month only may kindly be paid. But
No, no,
others
this is your thing.
Yes, but they have turned to Lordship may kindly turn to page 17. 1 and 2 they have accepted. And regarding 3, they say that they need to negotiate. Thereafter, petitioner initiated. And it is the admission of the petitioner that at a rate of 70,000 per month for 3 months it was paid. But rest has not been paid.
How? By cash?
No, but it was that information I have to take, my lord.
Lordship, these are those days, Lordship, we could not trace out the file, Lordship. Those days, those period days, Lordship. Those scam period, Lordship. Those scam period days, Lordship.
Those?
All the scam irregularities happened in this.
But what did you do with that officer against whom an inquiry was made, Sri Subhas Padgiri, AO?
Enquiry report is at page 18, madam.
What is that? What did you do with him?
Urges to approve at page 25 operative portion, my lord, down below.
On the other hand, you are saying by way of this notice that you agreed to pay 75,000. Now you are saying 70,000.
But here, Lordship, if his person is right, Lordship, I do not have record on the basis of the petitioner's record, Lordship. I have to say, Lordship, kindly turn to the page number 17, Lordship. The last paragraph, Lordship. In person of your terms and condition referring the letters, point number 1 and 2 is agreeable.
So that I've read it.
But it is negotiable. That means it is, if he is paying 70,000, then it might have negotiated, Lordship.
Yes, my lord, that is what they have negotiated.
They negotiated to 70,000.
If that is 70,000, then why you have stated at page 26 that you agreed to pay 75,000?
But that down below, my lord, down below it is written that.
But surprisingly, you have paid payment only for a period of 3 months at 70,000.
But petitioner is agreeable to 70,000. That is my instruction, my lord. Even if 70,000 is paid, petitioner is agreeable to that.
How many months?
Lordship, for it was started with effect from 22nd and
9 months.
March
He was
2017.
asking 9 months, 75,000. 9 into 70. He was asking 7 lakhs, I think, around.
Fishery development has got lot of money.
We have lots of money.
Yeah.
Now, Lordship, now we have accumulated.
Anyways, file your affidavit. You file your affidavit.
In any way, if I do not, in another way, I will file that.
I think you need to file.
Yes, Lordship, I need to.
Because that needs to be taken note of. Once you file an affidavit, there might be disputed questions of fact for which will relegate the petitioner. But this is not a forum for deciding all these things. Unless it is clear from any document to the document to show that this is the agreed term. They only say that we are going to negotiate. Nothing is shown except his letters. So, Mr. P. Sharma appearing on behalf of the AFDC seeks for 3 weeks' time for filing the affidavit. It is seen that on the earlier occasions also, the council appearing on behalf of the AFDC have taken time. Under such circumstances, this court, as a last chance, grants time till time for filing the affidavit on behalf of the AFDC. List the matter again on 13th of September 2024. The affidavit be filed by 3rd of September 2024. The petitioner, if so advised, would be at liberty to file the reply. It is made clear that if the AFDC fails to file the affidavit within the time stipulated, it shall be deemed that the petitioner, the AFDC authorities have duly accepted the contents of the petition.
God bless us.
21.
Lordship, here the petitioner challenged the notification that was issued by the DFO Nagaon at the time of filing this petition, Your Lordship. Now they have already been evicted and the prayer of rehabilitation is there. Lordship, similar petition was disposed of by the coordinating bench of this Nagaon court. That place.
Forest Department.
Yes, Your Lordship.
Hello, non-appealers, we take the advantage of that. Pass an order. Better than that. And also pay compensation to you. But tell me, the Forest Department rehabilitate you?
Well, we have filed an affidavit, they are still to file a reply.
Forget about the reply. How will the Forest Department rehabilitate you in another reserve forest? They didn't have any other land. The rehabilitation can only be done by the Revenue Department.
Yes, Your Lordship, the deputy, we have met party to a deputy commissioner.
So what? Why will the Revenue Department rehabilitate you? They have not done any wrong. Unless it is the government's decision or by way of a statute, you are entitled to rehabilitation. Mr. Gogoi,
My lords.
are they entitled to rehabilitation?
My lord, no. Because my lord, the documents annexed to those petitions also, my lord, if I recall properly, my lord, those are the patas, my lords. And my lords, their only claim is they have been residing that area for 30 years or more. If anything lies, my lord, that is to be taken up to the concerned, my lord, revenue authority, my lord, because we don't have surplus land to settle them, my lord.
Therefore, you cannot settle them.
No, my lord.
So, if they want rehabilitation, means what rehabilitation? Tell me.
But there is one policy, rehabilitation policy for the erosion affected families, which was introduced in the year 2000.
Erosion affected?
Yes.
How do you come into question of erosion affected? You are encroachers of the forest. Forest, there is no erosion. It's all a lot of trees.
Yes, sir. So prior to moving that area, they were affected by the flood, Your Lord.
Huh?
Petitioner.
Sir.
Their land was away. As a result, they moved. And no such document has also been annexed to derive to substantiated fact also, just a mere submission.
Yes, revenue. Are you going to rehabilitate them?
We have not received instruction yet, Lordship, regarding this.
Huh?
We have not received any instruction, Lordship. We have to communicate later, Lordship.
Because what he wants, an order passed by coordinate bench, wherein the order says that the writ petition otherwise has become useless, taking into account that the petitioners have already been evicted. However, they can file representations and the authorities shall within 6 months take a decision. Now, if they want a rehabilitation in the form of money, it's another aspect for which there has to be a policy decision of the government. Or they want to apply in terms with the land policy of Assam.
Yes.
You can very well do so by filing application. Why do you need an order? And you can't submit a representation. If you want to get a settlement of land, it has to be by way of Form 125 and 26 or apply by the Vasundhara system. You can't come up out there and this court will pass you a representation, because at the end of the day, they will come up with only one thing. And look here, they have not filed any application. How do we settle? Hello, let me dispose it. The writ petition heard Mr.
S.K. Chapmaya.
And so the learned counsel appearing on behalf of the petitioner, Mr. D. Gogoi appears on behalf of the Forest Department of the Government of Assam, as well and Mr. S. Datta appearing on behalf of the Revenue Department of the Government of Assam. It is seen that the petitioners herein have assailed the actions on the have assailed a notice issued by the Divisional Forest Officer, Nagaon Wildlife Subdivision, as well as the Deputy Director Kaziranga Tiger Project, Patimari, Nagaon, Assam, whereby notices were issued to the petitioners for eviction from the land under their possession. It has been submitted at the bar that the eviction proceedings have already been carried out, and the petitioners have already been evicted. The Land Council, appearing on behalf of the petitioner, submits that the petitioners therefore ought to be rehabilitated by the respondent authorities. No policy, however, is seen that in case of eviction being carried out from the forest land, the respondent authorities would rehabilitate the petitioner. And as such, the question of the petitioner having any legitimate expectation legitimate expectation for consideration does not arise. Be that as it may, the petitioner duly, if the petitioners fall within the ambit of the petitioners are indigenous people of the state of Assam, the petitioners would always be at liberty to apply for settlement of land, allotment and oblique settlement of land in accordance with the land policy of 2019. So, under such circumstances, the petitioner, if so advised, would be at liberty to apply in terms with the land policy of 2019. Yes, Mr. Upadhyay.
The lordship will see the earlier order, 19/6/2024. From record what we produced today. My
Yes. What is your case?
My father is a recorded tenant. My lord. And I am a cultivator. And then ought to have been settled with me, but instead of settling the land, the allotment has been made. The respondent number 5 and 6, my lord.
You are the recorded tenants.
My father was the recorded.
So under
tenant.
section
They have
6.
denied, the official respondent had denied, but later this honorable made inquiry, and on inquiry I found that my Khatian is genuine. That
Yes, what is this? If they have the Khatian first, they have to get it as per section 16. It is the ceiling surplus land.
But that DAG number 369 and 370 it has been cancelled by the SDLSC because it is transferred to some other. And that SDLSC.
No, madam. First and foremost, is this a ceiling surplus land?
Yes.
If it is a ceiling surplus land, it is the mandate of law as per section 16. First, you have to give it to them. We are not concerned with others. That is the mandate of law. So then how are you giving it to somebody else?
Allotted to his petitioner's fathers, but 369 and 370 that number instruction has received, lordship.
What does it say?
A circle officer report, it has transferred to someone.
Huh?
It is transferred there. DAG number 360 and 369 and 70 has been transferred some other person. They have transferred it.
Who transferred?
Petitioner's father.
Is it?
no.
Yes.
We are not.
How? Verbally.
Petitioner father died
1981.
On Sita copy also annexed.
Where is it written? It has been transferred.
In the circle officer report also, at the
Where?
end of second.
What does he say?
Tag number 369 and 370 was not in position of, 370 is not in the position of petitioner.
Or do you put us? Zombie, Louis, look, Pita, so and so. At the hard line.
No. King Sorkar land, how can he transfer?
May I submit, sir? May I submit, sir?
Yes.
This is a FC patta. It's a FC patta.
FT?
FC patta. It's a fee ceiling. It is for special cultivation of tea only. So he cannot cultivate any other thing other than only tea. Now his case is that he is doing cultivation of some other thing. That cannot be. So he then cannot claim to be a tenant under that company. That his father. That is one point.
Did you cancel the Khatian?
So he was not found in a position, that is the report.
Forget about possession. The occupancy tenant required to be in possession.
No.
He can cultivate from somebody else. But did you cancel his Khatian? How do you take care of section 16?
That is the difficulty, but this is.
That is the difficulty means that is the difficulty you have to face. How are you getting a allotment?
But
they will, if there are no persons in under 16, then only you can go to 17.
Yes.
And then take into action the provisions of the settlement rules and others. Otherwise, how do you deprive a person who is otherwise a recorded tenant?
That has to be cancelled first.
Which certain?
That 30.
No. The allotment, if any proposed to anybody, has to be cancelled.
That is a subsequent thing, but prior to that, how can I?
No. Affidavit filed.
That's it. We have filed our affidavit.
And how are you giving it to this IGCL? Acquisition.
SDLC meeting, it is allotted to IGCL, respondent number 5 and 6.
How?
On the basis of the report.
What? Is there a stay? Stay? Do you have a stay or not? No stay. No, we have to stop it, everything. Status quo be maintained. Are they running anything?
Yes.
IGCL.
They have already occupied.
What are they doing?
They are constructing.
Constructing. We need to stop it immediately. Yes, what do you have to say?
Construction is complete, my lord.
Who are you?
We have already constructed one pigging center here.
What center?
Pigging center also, because there's a pipeline going. So in some intervals, there has to be a pigging center to monitor it, the flow of the crude oil. So it's a Numaligarh refinery basically going for a big taking oil from Paradigm. So that's why this land was required. And we have been handed over this land as per the
When?
It was done on 22, but 22 acres.
Then what are you doing?
12,722.
Then
Then we have constructed this, further.
Chalo, we do one thing. This is in violation. We set aside this settlement today itself and then hand over to him. Do it as per section 16. Yes, anything you have to say?
But we have already, my lord,
Forget about what you have done. What entitlement your entitlement will come later on. First, his entitlement is there. Yes.
Understand it's 16, well, whether they were recorded.
They are recorded there. They are.
That has to be shown from the record.
It is there.
Only the Khatian is there.
Khatian is the recorded tenant. What else?
It's not like when this land was actually sealing surplus land, then at that point of time, whether they were recorded tenants or not. That has to be looked into.
You become a recorded tenant under whom?
Recorded tenant under a tea garden, because they say that they were the tenants of the tea garden. And they have, now they have produced this Khatian. Earlier, government has submitted one affidavit saying that there was no record. Now the Khatian has been, placed. Now, only thing is that like whether they were tenant or not at that particular point of time.
They were.
When it was
You see, a Khatian cannot be cannot be cancelled in this manner.
That's correct.
Hello, we said anything else you have to say?
No, but the construction is
We
complete.
set aside this settlement in your favor. Give it to
Construction
him.
is complete, my lord, then we are operating, my lord, from there, my lord.
So what? Either you acquire it, pay him the money.
That aspect can be looked into.
Very well. We'll take it up tomorrow. Think over it. Whether you are going to pay him for these two lands. Isn't that, Mr. Wang? Will you be happy with that money? Fantastic.
Day after
Be
tomorrow,
happy.
my lord.
Yeah?
Day after tomorrow.
Mr. J. Roy, the learner, senior counsel, appearing on behalf of the respondent number 5 and 6.
5 minutes.
5.
I am paid.
And Mr. A. Kolita, appearing on behalf of the respondent number 6, submits that they would obtain instruction as to whether an out-of-court settlement can be arrived at with the petitioner insofar as the land which have been settled to them. List the matter again on 9th of August 2024.
23.
And itate likhi dibo ha. In madam, it is further the district administration. Which district administration? Dorong is directed to file an affidavit bringing on record their instructions which have been placed
We
today.
have already filed our affidavit.
No, these. There. Yes. What is this?
I have filed a petition for my lord land demarcation of the school, my lord, the boundary, my lord. I am secretary of Sankotep Vidyaniketan, my lord. So I have, my lord, filed an application.
Yes, Mr. Sutia.
My lord, the petitioner has not stated all the facts, my lord. There is a dispute, my lord, in respect of the land of the petitioner. One PIL was filed, my lord. The division bench directed the principal secretary to make an inquiry. In that inquiry, they agreed that the school will be shifted to the another place of than 11 because, my lord. They have not shifted, my lord. Another PIL is filed, my lord, before this court, my lord, and the court issued the notice, my lord, to the petitioner. And it is not only a case of, my lord, simple demarcation, my lord. It is possession and construction of the land of the petitioner. Petitioner along with another person is also possessing the land. So, my lord, we have not yet filed the affidavit. All those facts are.
Petitioner area was to a respondent issue a rule to show cause why the land demarcation of the aforesaid land occupied by the petitioner school shall not be done. Yes, where have you applied for demarcation?
Yes, my lord.
have, my lord, we have submitted, my lord, the necessary fees, my lord, for demarcation, my lord. That is, my lord, at page 21.
Understood, but Mr. Jutia, why are you not carrying out the demarcation?
My lord, there is a dispute, my lord, another person is possession of the land, my lord, and the PI, my.
Whatever way, you are to, what is the demarcation? You don't throw somebody out.
My
You
lord, it
only
cannot-
show
it cannot-
him that this is the land.
My lord.
That's
but-
all, and give the record of planning, see him finished. What is wrong?
But my lord, my lord, there is a direction from the division bench, my lord, to make an inquiry, my lord, in respect of the position of the land of the petitioner, my lord. There's the school cannot be constructed, my lord, land, if the land is, my lord, less than 1 bighas, my lord. And so, my lord, they have filed this petition, my lord, so that, my lord, they can submit it that they have the 1 bighas of land. So it relates to that, my lord, order passed by the principal secretary.
But
and the
their
principal-
land which they are asking is 4 Katha 11 lectures.
My lord, the school is, but if they have demarcated, my lord, certain other portions, my lord, we have received the instruction, we earlier went there, my lord. The person who is in possession of the land, they have obstructed it. Without, my lord, the police force, my lord, we cannot. do that.
But they are not a party.
They are not party, my lord. The
Somebody
person who
else is in
possession.
possession.
My lord.
That, my lord, I cannot say, my lord, that.
Huh?
That, my lord, I cannot say this.
My lord, he has the knowledge, my lord. We have filed the affidavit and the
My lord,
principal
I
secretary
have-
passed the
I-
speaking order. And the division bench issued a notice to him
You,
also.
you file a short affidavit on
My
that.
lord, my lord, my
We
lord.
dismiss it on immediately
My
on
lord.
that.
My
Mr.
lord,
Jayasutia, the
seconded-
learned counsel appearing on behalf of the petitioner submits
3 days,
that
they have taken
the
my time.
petitioner herein, that the relief which have been sought for by way of the instant writ petition is is a mischievous relief in as much as the petitioner has not approached this court by clean hands. He further submits that there is somebody else in possession of the land where the petitioner is seeking demarcation, and by way of demarcation, the petitioner seeks to recover possession. This court, however, is of the opinion that these aspects be brought on record by way of an affidavit. So accordingly, list the matter again on 16th of September 2024. The affidavit be filed by 9th of September.
That your lordship, my lord, you may be allowed to file a reply against the affidavit of the respondent number
5 and 7.
Yes. They have filed.
Yes, what is this, Mr. B.P. Bora?
Lordship, they have come up against, I'm appearing for a biomedical waste 10, Lordship, I am appearing for 1 and 3. What has happened? After obtaining every clearance, there are 6 clearance required for building this. We have applied for every clearance, we got every clearance, we started the project. Now they come up with this petition challenging the consent to operate. Now the guideline says that anybody who is within 5, it should be located beyond 500 meters of population. In 500 meters, everything is a government land. They are not within 500 meters. Secondly, the petition is premature because there is no specific instance of any violation given. They are not personally aggrieved by any of the actions. Therefore,
Are you residing within 500 meters?
Yes, no, but we have submitted a complaint.
Whatever you complain, the complaint we are concerned with these
Yes, well,
persons.
of course, my lord, because the land are agricultural land.
So
Yes,
the distance become different if it is agricultural land.
Yes, the
No,
agricultural land is
absolutely no.
reclassified as a, my lord,
Commercial land, agricultural land, whatever, we should have a distance of preferably 500 meters. However, in case of availability of such land, the distance may be reduced to less than 500 best by their proprietor. Where do you reside within 500 meters? Have you mentioned?
yes, my lord.
Where? Where is your statement?
This page 30, my lord, paragraph 34.
Or, yes,
The petitioner states that in an answer to an RTI application, the Regional Executive Engineer, Pollution Control Board, Assam, RLO, Bongaigaon, so and so, states that as per revised guidelines for common biomedical waste treatment facility, common so and so can be located at a place reasonably far away from notified residential or sensitive areas and should have buffer distance, preferably 500 meters. However, in case of non-ability of such length, the distance may be reduced to less than so and so.
Jal Jeevan Mission Project. Who? Government. Shiv Mandir. It's okay, not necessary. So, this type of petition should be dismissed. In quantify the cost.
We may allowed to file the my lord,
Mr. BP Bora, kindly find out how much cost should be given for for environmental degradation of filing such a fact petition. Secondly, for unnecessarily spoiling the time of this court. How much?
Lordship deems fit and proper.
my lord, we may be allowed to file evident reply.
No.
My lord, here the my lord,
You
even the public
yourself
hearing-
has stated out there, no, there's not a single statement that you are having within 500 meters.
my lord,
There's no locus, Lordship. Locus is not there, Lordship.
No, Lucas.
no, Locus has
This,
come out.
this
my
is
lord.
a motivated Mr. Sinha.
No, my lord, the Madan Mohan Guhai Than Satra has come, my lord. They were the complainant. They were the complainants. They have approached the developmental authority. An inquiry was made, a public hearing was taken place. my lord.
This Hotra will have more money. So we'll put it at 1,25,000.
No, my lord, no, my lord, no, my lord.
You are the president of the Hotra.
No, my
So
lord,
we'll
my-
make it
my-
35
my-
for
I
you.
have to take instruction, my lord.
Secretary, another 35.
I will take instruction, my lord, kindly, my lord.
Goodness,
Some days time may be given. my lord.
4 days.
Yes.
Else I'm going to dismiss. This type of petitions are encourageous petitions. Mr. B. Sinha, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation to obtain instructions upon this court had specifically inquired as regards the locus of the petitioners, taking into account the contents of paragraph number 34. 34?
Page
Of
30.
34 of the writ petition, 34 of the writ petition. In as much as the as 34 of the writ petition, and inquired as to whether the petitioners, any of the petitioners, have their place of residence within 500 meters of the facility so set up by the respondent number 5 and 7.
1 and 3.
What you are?
1, the company.
1 and 3. Mr. B. Sinha submits that he will take instructions in that regard. So accordingly, list the matter again on good day for dismissal, 7th of August. And also I have prepared a cost, 125 for the petitioner, number 1 remaining, I make it concessional 35, president and secretary, others taking into account the age, I'll make it lessen it to 15,000-20,000. Yes, Mr. Goswami.
Petitioner Manu was expired.
Are you interested in the matter?
Yes.
What is that matter?
We challenge the notice that is at page 34.
30?
Page 34, man.
34. I'd like to say that during a routine survey, it is found that a permanent boundary wall at the edge of Bahini River in the plot of so and so. You are therefore here to remove the area wall of the aforesaid plot and not carry on within a distance of 6 meters from the edge of the Bahini River. Okay, then
Just come, my lord, after allowing us permission, my lord, which will also be annexed, my lord, to bring up our construction in that land, my lord.
Where?
That
Where is your
the,
construction permission?
19, my lord, page 19.
Where?
Page 19 here, my Beltola.
For what?
No, for construction of a multi-story building.
So,
Yes, my lord.
here, this is a case
No,
of wall.
This is not related to this, my construction. What has happened? my
No,
lord, they are
no. This is a
buying-
construction of a wall, isn't it?
They are standing there for 50 years, my lord.
100 years also good. But
And
this is
it
a
was
case
shown
of
in
wall.
In that site plan, my lord, this was shown.
No, this is the wall.
Yes.
Then it is a
No,
different thing.
not in-
But this permission is only for construction of a building.
Permission was for building, no permission for wall.
Wall.
Now they are constructing the wall and we're
No,
trying to.
Wall was already there, man.
No.
Well,
Lots of
it is shown in the map also, my lord.
Map? What
The
map?
site
Yes,
plan-
wall is
well,
there, lordship.
Wall is
But-
there. 50
But it is in a
not
dilapidated
constructed
condition,
even by
lordship,
me,
and
man.
they are trying to reconstruct. the wall.
My forefathers, man.
Have they stopped it or not?
Yes, notice has been issued, lordship.
Have you, they've stopped it or there's an interim order? For what? Not to demolish? The aforesaid interim order being passed with the proper instruction, the same shall be reconsidered after a year. The directed the boundary wall in it may not be demolished. Now,
Affidavit has been filed.
this is the boundary wall which is new origin.
It is a,
Boundary wall looks of a new origin.
no, this is
No,
the
no,
old,
madam,
old
this
one.
is-
lord. This is the old one.
Old one.
On the back side, lordship,
Old
they are
one.
trying to reconstruct.
Then also this looks new. Which one backside?
Some piling posts are there, lordship.
This is the one with the arrow.
This is the Bahini River, lordship.
This is the Bahini River.
Yes.
So this is one with the arrow. This is the one.
Wall is already the back side, lordship.
Wall is
See the-
alongside the stream, man. On the bank of it. Older than my.
Okay, you produce the building permit, the wall permission here, and else the JMC will do the needful.
That was
In the
constructed.
meantime,
my
I'll file
father's
my
time.
affidavit, lordship.
You want to file an affidavit after breaking also.
Instruction I received, lordship.
Yes.
Did they file the affidavit, man?
He got saved by you.
I will not take much time, lordship. I'll check.
No permission. He's there to file affidavits.
They got all the help and assistance from us, my lord, while cleaning the stream.
Huh?
They got all the help from us, my lord. We provided access, everything. They parked their big vehicles in our land, my lord. We allowed them, my lord, to that break down the vehicles so that they get access to the water, my lord.
Lordship,
Yeah,
under
the-
The learned counsel appearing on behalf of the GMC submits that he would like to file an affidavit as he has already received the instructions. List the matter again on how much time?
after 2 weeks, lord, any day.
List the matter on 28th of August 2024. The affidavit be filed by the GMC on or before 19th of August 2024. The petitioner, if so advised, would be at liberty to file their reply by 27th of August.
Also the.
Interim order passed
application
earlier shall continue.
Substitution, my lord, of the writ petition. He is expired.
Who?
He died. This writ petition.
When?
April, man.
Huh?
April 24.
So then we are passing an order against the dead person. Oh, Educato. It has been submitted by the learned counsel appearing on behalf of the petitioner that the appearing learned counsel that the petitioner had expired in the month of April. Accordingly, and seeks some time for taking steps, list the matter the 6 weeks. Order নহয় দেই interim extend করা নাই.
Interim.
No, how can I extend an interim for a dead person? My
That
goodness.
matter was not listed, man, for a
No.
long time.
Dead person, no interim.
The matter was.
I don't pass interim orders in favor of dead person. They will haunt me at night.
Madam.
Nothing. My goodness, dead person interim.
Obliged, lord.
May it please your lordship.
Okay, here the petitioner is praying for compensation that of the land acquired by an national highway. Certificate is in filed by respondent number 5.
What do they say?
They say that as I have not objected, so no compensation has been has to, but they has said that a part of my land and land 1 bigha 2 kathas land under my position and and 2 kathas of land.
Who are you?
I'm the principal.
Huh?
Principal.
You are asking money from whom?
From NSA ITC
Why?
as compensation.
You have given them, you have been paid for the Jirat. What else you want?
It's a land compensation.
Why? Land has been allotted to you.
Yes.
Where is the allotment?
Annexure 1. Page
Huh? What is that? Hereby it is certified that as per the so and so has been allotted to Deepsika. This is not an allotment. My goodness. You have no right. Yes, government. You are trying to take money from the NHIDCL through the petitioner.
No, Lordship.
Then your land.
Yes, it is government land.
Then government land you have not allotted to them. Have you allotted to the petitioner? So under such a, where is the question of land?
Yes, Lordship.
land has been allotted. Land has been allotted.
No, land is not allotted. Land cannot be allotted in this manner. You have been given this, the Jirat is very good. Be happy with it. And government, is government who is doing it.
Did I get a copy of the Jama?
Is this your land?
This is allotted land.
To no allotment. This is not an allotment.
So here in their affidavit also they have said that.
DC writes a letter in that. ADC writes a letter that doesn't mean an allotment. The allotment has to be in a particular, and the allotment does not confer any right over the land. The land has to be settled.
If I want to get a Jama copy because if they are paying the revenue at that point of time, okay. I have a case.
Allotment can't happen like this. You want what money? Jirat.
Jirat also is.
Huh?
Jirat.
Then what else? Nothing means. That is over. What do you want today? Dismissal.
Later I file an additional affidavit to bring the Jama.
Who?
I.
You want to file an additional affidavit bringing on record the?
Jama copy. If there is
Your name is there in the Jama Mandi.
land, since land has been allotted, and if I have paid the premium, Lordship, it will reflect.
You paid the premium. Show me.
Lordship,
Obviously, you can't. Why will you pay the premium, Mr. Counsel? It is a government school. My goodness. You should be happy with that money. Or you want to return the money to the government? Something like the government is.
On SITA also.
Government is helping you to file the writ petition.
On SITA, it is that number 118 is government.
Yes, definitely. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss. What does it? Union? Don't.
I can appear.
Don't. Then who is appearing? Who is going to appear for the deputy commissioner?
I will appear for the union.
Mr.
DJ Das.
DJ Das appears on behalf of the respondent number 1. Mr. A. Bhattacharjee appears on behalf of the respondent number 2 and 3. Mr. R.K. Talukde appears for the respondent number 4. And so Miss S. Burwa appears on respect to respondent number 5 and 6. The petitioner is a principal of, the petitioner herein is a school. What school is this?
LP school, Lordship.
Huh?
Primary.
Provincialized?
Provincialized.
Huh?
Provincialized.
Is a provincialized school of the government of Assam. Full stop. The Land Advisory Committee had recommended for allotment of 2 bighas of land covering Dag number 118 in favor of the petitioner. Subsequently, on account of acquisition, subsequently on account of the development of the 4-lane of 37 National Highway, acquisition proceedings were initiated and the land of the petitioner was taken away. In that regard, the petitioner was only paid a Jirat compensation of an amount of rupees 11 lakhs. How much? 11 lakhs, how much? Is how much? 11 lakhs? 10 lakhs 33,766. However, the petitioner was not paid any compensation for the land. It is under such circumstances the petitioner has approached this court by filing the instant writ petition. From a perusal of the documents on record, so filed by the petitioner, and there is nothing discernible to show that any land have been allotted, have been settled with the petitioner. On the other hand, the affidavit which have been filed by the respondent authorities, more particularly the respondent number 5, categorically shows that the land in question was a government land. Under such circumstances, the question of the petitioner getting any compensation from the respondent authorities, that too being a provincialized school of the government of Assam, does not arise. Accordingly, the instant writ petition, being devoid of any merit, stands dismissed. Be that as it may, this court, however, observes that if the petitioner is aggrieved with the compensation so paid in terms with section paid as regards the Jirat, the petitioner would always be at liberty to approach the competent authority in terms with section 3G of the National Highways Act 1956.
7.
I've got the instruction. They are praying for some reasonable time. They have taken it with utmost priority manner.
Which one?
Last order, Lordship may see.
On 23rd, Lordship has passed an order asking the finance department to take instructions as to the sanction
The
of
finance and GAD. both.
Okay, now what to do?
Some reasonable time manner, they are taking up the matter.
Who is going to pay the tax interest? Who is going to pay the interest on this? It's a huge amount.
Yes,
2 crores 16 lakhs.
16 lakhs.
And how many years they have taken the position?
Yes, more than
2 years. So it is 15%. So you are paying for the finance also? Fantastic. Let the commissioner and secretary pay Finance Department B pay
He
from
is
his
not the
own pocket?
authority, my lord,
Huh?
until and unless the proposal is submitted to the finance.
Or then let the Joint Secretary, Government of Assam,
Yes.
General Administration Department pay
Lordship.
from his pocket. Somebody has to pay. It cannot be a burden upon the taxpayers.
Lordship. No, Lordship.
So it has to be by the officials. I'll observe.
No, Lordship, you will give us some time. Let it be
I'm
after
giving
2
it,
weeks. So after 2
provided
weeks,
whatever delay occasions is at the cost of the salary of the airing officials.
there also I will have the instruction, my lord. Let it be after
Absolutely.
this 1 week. I
You
will
take
convey.
it instructions,
Yes,
you take, I give you 6 months.
No,
Today
my
there
lord.
was one matter, council sought for 1 week. I gave them time till 23rd of November.
So just I
But the
want.
thing is that later on they said I'll get the instruction by 2 o'clock. And we dispose of the matter at 2.
Today it's too late.
This
my lord.
can't
Let
happen
it-
like
yes,
this.
I understand. my lord.
Who is
Let
going
it,
to pay the interest?
I understand, my lord. So let it be on Monday in that case. my lord.
Yes.
At least 3 days.
Mr. Because this, Mr. Bigugoi kindly appreciate one thing. I'm not concerned with all these things when he gets the money.
Yes.
But the question, if he doesn't get the money, there will be always a multiplication of an interest, which is at the end of the day, time harming the public finances. Either you should not take up any position. Here is a case you have taken for the purpose of construction of the district headquarters of Kamrup. And the DC has no money. Take his telephone. Okay, it has been submitted. This is notice has been issued, na?
Yes, yes. my lord.
Okay. Oh, nothing was happening earlier. See? Matter was not moving from 2023. The learned Mr. B. Gogoi, appearing on behalf of both the finance, appearing on behalf of the finance and taxation and the finance department of the government of Assam, as well as for the GAD department, submits that the finance department has been moved for payment of the amount as payment of the amount of rupees 2,16,03,820. He submits that some reasonable time is
No, it has
required.
not been moved, my lord. Lordship will see para 4.
That is what I'm
Three and
about to dictate.
Yes. No, that statement, my lord.
He further submits that upon moving the finance, some time will be required for obtaining the sanction. In as much as the GAD department does not have funds.
Lordship.
Full stop. This court having taken into account that in the year 2022 itself, the land of the petitioner have been taken and taking into account that the interest would accrue at the rate of 15% now, 15% at present, in view of the mandate of law, delayed by the finance department in granting the necessary sanction, in effect would hurt the public exchequer in as much as such amount, additional amount has to be paid. Under such circumstances, this court fixes the matter again on 12th of August 2024, on which date Mr. B. Gogoi shall obtain instruction, give an update as to whether the finance department of the government of Assam have granted the sanction and further have granted the sanction. The instruction so submitted before this court is kept on record and marked with the letter X.
28.
Yes, what is this?
This regarding victim.
Ex gratia?
No, my lord, victim compensation.
Which one?
My lord, pays 55, my lord.
65.
Percent of order, my lord, first by your lordship, my lord, the DLS has sanctioned the amount of rupees 5
I
lakhs.
proceed to make an inquiry. The inquiry notice have been issued and I approve the order dated so and so in regard to this remand and the case order has been revised to rupees 5. Therefore, the matter is hereby placed before your honor for remand. Having perused the record report of so and so, I am of the view the victim may be paid the amount. Well, they are not paying. Yes. Which department? Political.
Home and political.
Home and political. Where is that home and political? Yes, madam, you are there. Why you are not paying?
Sanction proposal has received from State Legal Service Authority and it is sent to Finance Department, Budget Department.
So, you are having a scheme. These are schemes under 357A. It is the mandate of the Supreme Court categorically saying the 357A, comply. And to show to everybody, you have come up with a beautiful scheme, Assam Victims Compensation Scheme 2012. It looks very fine that the Assam government is providing such good compensation. But at the end of the day, nothing is happening. Well, give an update.
Finance.
The Learned Counsel, Mr. S. Burwa, appearing on behalf of the Home and Political Department of the Government of Assam, submits that that for the purpose of sanction, the matter has been moved to the Finance Department. Mr. Bigo, who is appearing on behalf of the Finance Department, submits that he would obtain instructions in that regard. So, taking into account that the directions which have been passed, taking into account that it is the scheme under which the petitioner is entitled to, and delay in making payment would not be in consonance with Section 357A of the Code of Criminal Procedure 1973. Would not be in consonance with the avowed object behind Section 357A of the Code of Criminal Procedure 1973. This court fixes the matter again on 9th of September 2024, on which date both the Finance Department as well as Home and Political Department shall apply, give an update as to whether the amount has been released to the petition.
Obliged.
Sorry, Lordship, this matter I made a mention. There was some miscommunication in the department. Not full principal payment has been made a lot.
Only central plan was
Central,
made in
yes.
2019. Thereafter, now there's a development and we trusted that because of that. Even though a cat and mouse game is being played with us, they called us for a meeting with all our papers. We went for the meeting. That was on the,
They say that there is an out-of-court settlement
Now,
proceeding.
now 35, they call the meeting, said let us sort out the matter. Because there's phenomenal amount of interest under the MSME Act to pay us. And so we went for the meeting. Now they said that you furnish all your documents and we shall look into the matter. Again, we'll have another sitting. But after May, nothing has happened. So my prayer before Lordship today, let them expedite whatever they want to see. And let us live. Because our factories have been closed down one after another. We cannot survive. They are small scale industries.
That's the issue I had to take because out of court settlement, even I was informed there was going to be out of court settlement. But after that, what has happened to that? I'm not being informed. I take written instruction on that, Your Lordship.
Let him produce the minutes of the meeting.
Yes, I will ask for that.
Let him produce the minutes of the meeting.
Does the MSME Court Act is made with some avowed object that we are going to give such benefits, isn't it?
Yes, Your Lord.
And the government also says so, that we are giving so much to the MSME. When the question comes of payment,
and interest, then MSME Act is not so good. Something like that, or otherwise what?
Lordship,
Tell me.
the policy is that procure from small scale, right from beginning.
Yes, it should be
Now,
given, they
right
should be,
away, it is
they are given everything so that it is a boost to the MSME sector.
Let it be fixed on Monday, Lordship. The minus you can produce on Monday.
Let me get the written instruction including minutes, Your Lordship. Let me get the written instruction on this.
Not so soon. We'll fix it on 19th of August.
Very well, Lordship.
Find out something if it happens.
Yes, Your Lordship.
But if I am taking up the matter next time, be more serious. Huh?
I think it's time, Lordship, because we have suffered a lot.
Understood, yes. It has been submitted by the council appearing on behalf of the PHE department that the department is trying to enter into a negotiated settlement with the petitioner. And in that regard, some time may be given. It is seen from the earlier orders passed by this court that similar requests were being made. So under such circumstances, this court fixes the matter again on 19th of August 2024. So in the meantime, if the parties are not in a position to settle, the instant petition would be taken up for disposal on its merits.
Public. Before.
Nikki?
All are connected, those are. Up to
34 is different.
Up to 33 is connected.
Yes, what is this?
It is a Lordship. Lordship, in this case, there was a right to information application that was filed by the petitioner. There was a right to information application that was filed by the petitioner regarding certain information of his parental land. Till date, no information has been provided to him, Your Lordship. There was
By
circle officer.
then right to information. Appeal.
The appeal has been filed, Your Lordship. On the appeal, they ordered the circle officer to provide the information within 7 days. That has not been done. The petitioner also went to the Chief Information Commissioner, but it was not taken up during the time limit that is prescribed under the RTI Act. As such, he had come to the High Court. As such, he had approached the court, Your Lordship.
Understood. Why you are not taking action for penalty? 20? Section 20?
That concern was raised before the Chief Information Commissioner, but he has didn't pass any penalty.
What information you want?
Lordship, so his land has been mutated in the name of one of his brothers, Your Lordship. And mother. But one part of the land has been transferred only to one of the son, one of his brothers.
What is the information? Let us see.
Lordship, it is on page. Lordship may take up my
Information provided.
petition,
Please
Lordship.
provide the
On page
legal
20.
provisions and orders copies as per the name of the eldest legal heir was removed. Please provide order copies and all supporting documents pertaining to the transfer of land bearing so and so to Manoj Deka as to which he was allotted patta number.
So he has been allotted a separate patta and dag number, Your Lordship. It has been mutated in his name. But if the petitioner did not provide any NOC, no relinquishment, nothing, that it has to be mutated in his name, Your Lordship. As such, he wanted the information from the circle officer so that he could take the appropriate steps. But no information is provided to him. He cannot.
Yes,
take any
what are
steps.
these? You have enclosed something? Page 33, 34, 32.
Lordship, this is a Jamabandhi that the petitioner holds, Your Lordship.
Your name is there.
Yes, sir.
Has been struck off.
It has not been struck off, Your Lordship, but part of the parental land has been muted in the name of Manoj Deka now.
Somebody else.
Yes. He is one of his brothers. Your Lordship.
Then?
Lordship, he wants to know how that mutation took place, Your Lordship. Because he didn't give any relinquishment. Nor did he give any NOC.
He
with
wants
regard
to
that.
know how the mutation happened.
The orders and everything, Your Lordship. The
You
orders,
require those orders.
Lordship.
You don't have the order
We
copies.
do not have anything, Your Lordship. Because while this was done in the year 2015.
Why you are not providing?
It's
not available, Lordship. Not found in
Huh?
the, it's not found in Lordship.
How is it possible? When did it happen?
14.
in 2015 it happened, and he filed the RTA on 17 to 2023. Since then, they have all the response from their side is that it is untraceable.
It's untraceable, what to do?
Lordship,
They
as per
should create
public-
one.
Assam Public Record Act, like the meaning of untraceable cannot be a legally tenable excuse from their side, and under section 8, it is not also. an
Hello,
exception.
we take up this matter for a more interesting day. Will require, who is appearing for the private respondent?
But they're not part of it.
Huh?
There is no private respondent.
How are you asking for all these
It is
things
the
without the
RTA.
private respondent being made a party?
Under RTA Act.
So what? He may have a right under section 8. It may be a case of private documents.
Let the circle officer.
No, first you are asking how a name of somebody, some X name has been brought in without making the private respondent. How is it possible?
Because we are not challenging his mutation in this case, Your Lordship. We are
You
just
are
challenging
not,
the
you are
documents.
asking a document by which he has got mutated. Now the question is, whatever orders have been, you are not asking for filing contempt against that.
No, Your Lordship.
You want that the order, this court should pass an order. Now, whether the private respondent would have a right of say as to, look here, kindly don't give these documents, these are my private documents. His name got mutated. How can you, without making the private respondent file a distribution?
Lordship, because the NOC has been filed, if there is a NOC, it would be filed by the petitioner. That document will be made available to us. If we have given any NOC for the mutation.
Counsel appearing on behalf of the petitioner, this court, taking into account the matter and the paucity of the time in taking it up, adjourns the matter to be listed on 19th of August. If I get the matter again on that day without an application, be sure on dismissal on the ground of non-joinder of necessary parties.
I'll do that. Oblige.
What is this? Sharma? What is this?
Long history of
Human rights?
harassment by the local MLA and the police OC. Everything narrated in my petition and cases were filed by.
Read in the nature of mandamus should not be issued directly, provide adequate police protection to the petitioner and family. And why the state has to the immediate action upon the complaints and FIR filed against the private respondents. Who has done what to you?
MLA and the local OC, my lord, we give full details.
Remember, who is appearing for respondent number 8? What are you, why are you disturbing him?
But it is the presumption, Lordship. Never we disturb him.
There are,
And some cases pending against him also, he arrested also.
Yes.
As per my information, Lordship, he put in jail also, Lordship. But his presumption is, I am disturbing him. And I am not the necessary party here also, actually.
Why?
Because Lordship, their prayer is to register a case against me, Lordship, against the government. How I am a party here?
You are BJP?
No.
You can't be BJP.
No, I am AGP. He is
AJP, yes.
the Trussell-
You are BJP?
Yes.
I am BJP.
MLA. There is a Trussell
Yes,
start.
yes. Why police is not filing?
We will file the affidavit, Lordship. We'll file.
Mr. N. Goswami submits that he would be filing the affidavit in the matter. Or you will file affidavit?
Affidavit, after government affidavit,
No. There's no he government files, I file. Government does not file, I won't
comes
file.
against me, Lordship, because government has to do it.
So we'll deem that you have accepted what he is alleging against you.
Lordship, I will file.
Fantastic. Mr. So-and-so appearing on behalf of the private respondent also submits that he will file affidavit. List the matter again on 9th of September and 11th of September. The affidavits be filed by all the respondents on or before 2nd of September. Petitioner, if so advised, would be at liberty to file the reply. What is this?
To read petition, we challenge the notification issued by the state of Assam, the standard SOP.
Oh, the bullfights.
Bullfights. That's a buffalo fight and the bulbuli fight. This was put to challenge. And my lord, the notification which was issued by the state government, there's for a particular, this is indefinite, because they have not said that the notification for a particular period. So we challenge it. So now challenging after that also those buffalo
Yes,
fight.
yes, madam. You got one order in this type of matters, na?
Yes.
Oh, you will be affected with this.
No, we have annexed that order also.
No, my lord.
No.
At that point of time, that notification permitted me to,
Now you don't want.
but that notification, as far as I remember, was limited to a particular period because buffalo fight and bulbul fight, they take place in the month of January, 15th, 16th, at that point of time, first day of Magh. It was permitted for that period.
So you submitted last time that there was, because the entire basis is on that, the Kerala or something, the Jalikuti or something to that. And that has been reviewed.
No, that's my lord. After A. Nagra judgment, there is a judgment, constitutional bench judgment, which was reviewed because these three states, that is the Kerala, Maharashtra and Tamil Nadu, they amended the act and they have taken the assent of the president and they have filled up that lacuna. That is why the constitutional bench said, as they have taken the assent, so it is not in contravention.
Oh, but India, the Assam has not done it.
No, that's no act. That's why we have
You're
come
going to do
forward
it.
for a certain period we have allowed them. But even then, what we said, my lord, we
Certain
tell-
period was there. At that point of time, they didn't wake up and file it. But now, next time, what is going to happen to the bullfights?
either we have to, either
The buffalo fights,
amend the provisions of those act, my lord,
and
or,
take the consent of the president.
yes, either, or we have to, we cannot allow them to hold. Well, what I'm saying, this.
So is it your stand now, the government, that you are not going to do anything?
No. In the earlier case, my lordship.
No, no, the earlier case, she also
IFAS,
says,
IFAS.
that that was only for a particular period.
No, our stand was, my lord, we had, we did not allow them to hold the, following that decision in Nagar.
That was the old matter.
Right.
And there was a stay being granted by Justice Rishikesh Roy at that point of time. And thereupon, nothing was happening. And it was the basis on which the stay was granted is nobody was interested. There's a difference between that fight and here this fight out here. And here they have also they done so without taking into consideration what would be the impact upon these birds. Isn't that the reason why? And accordingly, this court has passed an order to that effect, and more particularly in view of that notification.
Right.
Now, that notification was for a particular period. Now, if it is your submission out here, that now you will say that, okay, no more bullfights and this bulbuli fights and all these things, or we would only do so after making necessary amendments, after taking the presidential assent. Nothing further remains in the petition. We'll construe this to be your undertaking, file an affidavit in that regard. We'll close this petition.
What I'm saying, even your lordship, that's what we said. Either you, my lord, will state his notification, nothing, your lordship, right, what remains in a notification? Take, your lordship, right, take the assent of the president, of course, no. Then, my lord, we don't have any grievance. Till date, they have not done it. Till date, they have not done.
What?
This notification is stands. Neither they have taken the assent of the president, of all other three states have taken. That's why the constitutional bench said that they have taken the assent of the president. So there is no violation. Now today, notification issued, and there is total violation of the central law, my lord.
No, that notification was for a particular period of time, I suppose.
For page 42, kindly see my, if your lordship
But
is holding
I don't remember it was for a particular period of time.
27th of December 2023, my lord.
Hmm.
At page 42, my lord.
Has cabinet have decided and others can be allowed to organize traditionally over the years and home fight of so and done in so and so. SOP is prescribed for buffalo fight and bulbuli fight. Then this is not for a particular period. Three, 4, and 5, the petitioner is directed to take steps by way of registered as well as usual. You have urgency?
See, the construction is almost completed.
So you know I have no urgency.
I have urgency.
Mr. Esbora further submits that the affidavit on behalf of the GMC has already been filed. GMD has already been filed. He further submits that the affidavit on behalf of the GMC would be filed within the next returnable date.
What did he?
Wait, Vijay. In this case also, the matter has been listed.
Notice has not been issued.
No.
What? List, will direct this matter to be listed Friday?
On motion.
For motion? List the matter on Friday. For motion.
All right.
By Friday, I'll take a steps now.
Orders. Orders me. Not taking steps.
Probably not given money.
Yes, sir. By Friday, I'll complete it.
From the last date of order.
Mr. B. Senior submits that he would take steps as directed by the order dated 28/6/2022 within 2 days. Taking into account the above, list the matter again on 23rd of September 2024. Yes.
Friday, your motion.
Motion. Why did that come? Is the matter for motion on Friday? Mr. Srivurva, what has happened that matter? That matter, the review I had taken, remember? Oh, that arbitration.
Oh, Lordship. Arbitrator has been appointed. Now.
It's functioning.
Actually, he's functioning, but so far.
But there is a requirement of having more arbitrators, no?
But I suggest.
Disposed of?
Yes, that has been disposed of. That has been disposed of. One arbitrator has been appointed.
No, that I know.
He's also, I think, not functioning. I have heard that he's sitting now also in Secretariat. And it's very difficult for us, my lord, to go there.
No, today I know one order, I mentioned it out there. He's sitting now there in the CM's block, old CM's block, Secretariat.
Because for us it is, my lord, actually really difficult.
It will have a havoc something.
Moreover, we have to take pass and all the things to go there. Anyhow, my lord, I'll let you know this. For guess of.
CVM
Every Lordship. Matter will be taken up on Friday, Lordship. The
Right.
Senior has went away on
Fantastic. The affidavits have been filed?
Yes, Lord.
Huh? Fine.
Yes.
You file a reply? You don't want?
I will file.
Okay, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that he would like to file an affidavit, reply to the affidavit filed by the respondent state. Who's taking into account the above, list the matter again on 25th of September 2024. In the meantime, the reply be filed.
Hello.
But in compliance with Lordship's direction, they have demarcated the land, Malad. The report of the circle officer is with me, Malad. As per the report, Malad, land measuring 5 lecha, which is not in possession of the next of kin of the Amal Chandra Goswami, Malad. Actually, they ought to have 1 katha 13 lecha land with them, but they have 1 katha 8 lecha land in possession. I'm just placing the report of the circle officer.
What was the direction?
Direction is to below. To
Demarcation.
demarcation. They have
We have
final-
demarcated.
Yes, sir.
The instant contempt application has been filed alleging deliberate violation of the directions passed by this court dated 17/2/2023 in writ petition number WPC in writ petition number 6152/2021. This court have duly perused the said order dated 17/2/2023, wherein there is a direction upon the respondents to dispose of, to carry out necessary demarcation in accordance with law without any delay. It has been submitted by Mr. D. Nath, appearing on behalf of one of the respondents.
Respondent number 1.
Respondent number 1, that the demarcation has already been carried out on 29th of May 2024, and in that regard have placed the demarcation report. Should I keep it?
This is the report of the circle officer, Malad.
Should I keep it?
Yes, Malad.
Yeah. I placed the demarcation report before this court. So the said report is kept on record and marked with the letter X. So taking into account the above, the contempt, the order dated, taking into account that the order dated 17/2/2023 passed in WPC number 6152/2021 have been duly complied with, the instant contempt proceeding stands dropped.
Well, in the bunch, the first and second pages are the report. The other rest of the pages are 2019 and all.
You help him, you just give it.
I'll-
Give me.
Lordship.
You give a copy to her also.
Yes. 49. Well, this is the review application. Well, we have paid for review of honorable court order dated 11/9/2023. Well, Lordship will come to the order at page 17. Well, it starts at page 18. Lord. Paragraph 3, Lordship has said, today when the matter has been listed, MS Bormon so-and-so had placed an instruction issued by the ADC Kala Biswanath, wherein it has been admitted that an amount of rupees 11 lakhs to be paid to the petitioner, for which the proposal have been submitted to NHIDCL for sanction. Then taking into account that it is an admitted fact that an amount of rupees so-and-so is to be paid to the petitioner, this court therefore disposes of the instant writ petition with a direction to the respondents, and more particularly the respondent number 3, to take appropriate steps for so that the petitioner receive the remaining amount of rupees 11 lakhs. Look, thereafter, when the matter was processed, ultimately, my lord, the instruction which Lordship has indicated is at page 16. I have annexed that, my lord. The previous page is the instruction. We said, my lord, that It appears that the claim of the last second paragraph I am reading, my lord, it appears that the claim of the petition is genuine, hence proposal have been prepared for an additional amount of rupees 11 lakhs, which will be placed to NHIDCL for sanction. My lord, after the honorable court order, it has been placed, but finally at page 25, lord, you will see, they are making some queries, my lord, and ultimately the amount has not been released, and therefore the amount could not be released till date. 5/12/2023. They said there is some error in the calculation and all, and accordingly we have.
What are they saying?
Hence it is clear, para 2, Lordship may skip 2.1, then 2.2. However, it has been observed that 12% additional amount has been applied on the value of the land as well as assets, which is not in the line with the provisions of National Highway Act 1956 as stated above. Moreover, in the revised 3G award also, the 36% additional amount has been applied on the total value of land after adding the multiplication factor, which is again also not in the line of the provisions of the National Highway Act 1956. Also,
Where is the land?
But
Where is the land?
land is it is already utilized. Land is utilized
No, where is the land?
at Bishwanath Chareli.
Biswanath Sarili. So therefore, Section 26(2) of the right to fair compensation applies. And in view of 106 of the National Right to Fair Compensation, the fourth schedule was not applicable for a particular period of time, 1 year. And if it is done after 2015, then obviously they are to do it. They are to give as per this they cannot say that they are not going to go as per the multiplication.
Ultimately, my lord, what my prayer would be, Lord, the NHIDCL was not a party in this petition. Lordship has directed the ADC to pay the amount. The amount is to be given by the they have to release the amount. Now, the page 27.
But I think when you see, you are the competent authority. You being the competent authority appointed under 3A.
They have calculated.
So you have the power to pass an order, and NHIDCL shall pay.
In fact, from kindly similar from page 21 onwards. Page 20 onwards, these are communications at NHI 3, page 20. On 18/9/23 onwards, till page 27, communications and clarifications are given, but the amount is not being paid. And the petitioner is again.
In fact, it should be the NHIDC who should come. The case of review. Anyways, you don't want to issue notice.
Before issuance
Notice making it returnable on 23rd of September 2024. Steps be taken against the respondent number 1 and 2. On behalf of Mr. S. Dotto appears on behalf of the respondent number 2. As regards the respondent number 1, the petitioner is directed to take steps. The review petitioner is directed to take steps by way of registered as well as usual within 3 days.
No, it is not. That's one. May I please know? My lord, I am appearing for all the private respondent. My lord, I may allow some time to file the affidavit.
Mr.
A.R. Mehdi.
A.R. Mehdi, appearing on behalf of the respondent, submits that all the private respondents submits some time may be granted for filing the affidavit. Taking into account the service is complete, list the matter again for admission on 27th of September 2024. The affidavit in opposition be filed by the respondents on or before the next date.
The item number 48 documents. No, I have to take a copy from that only.
Huh?
In the contempt case, Lordship, I have to take a copy from that.
Please. 51. Yes, what is this?
the petitioner number 1 to 60, who are before your lordship, they are seeking registration of their Bharat Stage 4 two-wheelers, lordship.
Huh?
Bharat Stage 4 two-wheelers. There was an order passed by the Honorable Supreme Court, which your lordship will find at Annexure P7. Because of that, there was an embargo of registering these two-wheelers.
Well, nothing remains now.
We need a direction from this honorable court. Otherwise,
Okay.
without it, because otherwise, my lord, the respondent number 5, who is the DTO, they have filed an affidavit saying that all the vehicles that were sold were prior to lockdown and they are genuine. There is an affidavit on record.
Okay, why the matter has come up for admission today?
Orders, my lord, the.
Orders.
The respondent 3 and 4 has not entered appearance. However, my lord, I have filed the Dusty affidavit on Dusty, and there is an office note dated 27/5/24. Notice has been issued, and the last order passed by this honorable court says that even if
The matter shall be proceeded in accordance. It has been duly accepted. Okay. Taking into account that the service is complete, list the matter for admission on when?
he did.
Admission on Court खुला से नहीं है, September.
Then next week.
खुला. Close. 2nd, 4th, 6th of September.
Much obliged.
Q1.
Oh, what happened? We got it cleared.
Lordship, in fact, already I have been informed that we are having no objection, but
Put it on record by 5. Bring on record something.
Give me 1 week's time, Lordship.
Huh?
Give me 1 week's time, Lordship.
We have taken steps on 29/7. Okay. Mr. R.K. Dev Chaudhary, appearing on behalf of
1, 2, and
the learned, appearing on behalf of the respondent numbers 1, 2, and 3. Submits that another 3 week, another
1 week.
1 week time may be granted to obtain the instruction as sought for by order dated 22/7/2024. Full stop. Accordingly, list the matter again on 9th of August 2024. The interim order passed earlier shall continue till then. Yeah, Mr.